Any mention?
Lordship, I beg to mention item number 16, Lordship.
Mr. P.T. Samastar available?
Yes, Lordship.
He is there.
Singar Hills, Lordship.
16.
Yes, Lordship. 16 and 17
This
connected.
matter has been stuck for... Where's the other side? She is weeping now.
No, it's okay. Since he is not out of station, but your lordship, next date I may be allowed to. No, file was some gist of the case, your lordship. Little.
You want to disturb?
I'll want to file some bullet points on bullet points.
Let's see after that vacation.
Okay. Yes, your lordship. So, your lordship, then in that event, your lordship, the case may be fixed after 21st April.
Okay, after 21st April, yes.
Much obliged.
Please, Lordship. Lordship, I beg to mention item 27.
Item number?
27. Lordship, I pray for 2 weeks' time, Lordship.
Why?
Lordship, the conducting counsel has some personal difficulty.
You conduct the matter now. Small matter, the service matter, correct?
Yes, Your Lordship. This termination from service.
1 week, okay. Otherwise, you argue it. Yes.
Your Lordship, similar prayer for item number 24. Your Lordship, here the settlement process is still going on, Your Lordship.
After 1 week, yes.
Obliged, Lordship.
Wait, please, Your Lordship, I beg to mention item 18. Since the conducting counsel, A.R. Pasa, is indisposed today, Your Lordship, so I'm praying if this matter
18?
can be taken up. 18, Your Lordship.
What's the matter about? Very interesting.
Pertaining to the...
Yes, that about that succession certificate.
Yes.
Lordship, just 1 week's time, Your Lordship.
Okay, 1 week as the conducting counsel for the appellant
Your Lordship.
is indisposed.
Much obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item number 23. I pray for 1 week.
23. Where's Mr. Paul? Or did you inform them?
No, Your Lordship. I
Then,
could not inform.
where's the juniors? These matters kept on coming. None of them are here. You inform them otherwise.
Okay.
When?
1 week.
Okay, 1 week, yes. You inform them.
Please, Lordship, I beg to mention item 33 and 34. Lordship, we were supposed to file our rejoinder and bring that we will be
30,
allowed to
34,
file
at
the post
rejoinder,
of the-
33, 34. Why rejoinder in the hearing?
As per the last order, we are supposed
Then
to file
meanwhile,
our rejoinder.
will be hearing, will be heard. When you go file? 33. Meanwhile, it will be posted for hearing and you file rejoinder. Why didn't file rejoinder?
Lordship, we will be filing our rejoinder in the course of the day.
Because of the, let me see. Okay. Yes, MSE one young service that as a rejoinder after will be filed the course of the day. She prays aloud.
Lordship, I'm
She
pre
prays that the matter will be up to 2 weeks. Yes.
Lordship, I'm pre-interim order may be continued. Interim order
Interim order.
may be
So,
continued.
who's other side? You inform them? No. You should inform them. 2 weeks, yes. You serve a copy, yes. Out of 2 week interim order of any shall continue till next date, yes.
Please, Your Lordship, I beg to mention item 22, Your Lordship. The conducting counsel is not available, Lordship.
22 is what, Majai? This matter also just 22.
Yes, Lordship. Being 2 weeks' time, Lordship.
You inform the other side?
No, Your Lordship, there's no one, so I'll inform them, Lordship.
2 weeks, okay. But please inform, yes.
Yes, Lordship. Obliged.
No, he's there. He has objection? Okay. Yes.
Please, Lordship, I beg to make a mention for item 32. Lordship.
Somnath Nath.
Yes, Lordship.
Your Lordship, in fact, we are still awaiting rejoinder also in this matter. We've not
You
received.
have not filed rejoinder?
Lordship.
You have no idea?
No, Lordship.
No
She
idea.
didn't have to brief with me, Lordship.
We need to go file 32. Yes, in the meantime, petitioner filed rejoinder. I just sought behalf of the petitioner, due to persons difficulty. Also prayed that we allow 1 week's time for rejoinder, yes. Further 1 week's time, prayer allowed, further 1 week's time allowed for rejoinder, yes.
Supplementary list, item number 1.
Please, Your Lordship.
1 second. Yes.
Please, Your Lordship. Lordship, the petitioner here in my lord is the absolute owner and in possession of a plot of land measuring about 1 bika, my lord, situated at Danakre, Machakulgri, my lord, Tura. So the respondent number 6, my lord, is trying to dispossess the petitioner number 1, my lord. Respondent number 6 is the son of the petitioner, my lord, herein. So he's trying to dispossess the petitioner from her own property, my lord, by taking coercive means, my lord, for which petitioner filed a title suit before the Assistant to Deputy Commissioner, my lord, Tura. And misapplication was also filed, my lord, for ad interim injunction, my lord, which is posted on 4th of April, my lord. So taking advantage of that long date, my lord, the respondent number 6 is trying to dispossess the petitioner, my lord. And for that, an FIR also was lodged, and police did not take any action, my lord. Thereafter, a complaint was lodged, a complaint was filed before the SP also, my lord. Then also, no action was taken against the respondent number 6. And recently, my lord, on 12/3/2024, with the help of the police, my lord, they went to the property and tried to dispossess the tenant, my lord.
Possession of this.
I'm in possession, my lord. The petitioner is in possession
What
of the
is this?
property.
What's this? You say Sangma Car Pollution Testing Center.
Lordship, that is in my name.
No,
That is
who
in the
runs
petitioner's
this-
name, my lord.
Who runs this Sangma Car Pollution Testing Center?
It's run by the son, my lord. But we have by the son.
That means he's in occupation.
No, I'm in occupation, but the tenant is there, my lord. Small portion, my
Who
lord.
runs this pollution testing center?
The pollution testing center is there, my lord.
Who runs it?
It actually is run by the son. The license, I'm the license holder, my lord. I am the license holder. It's run by the son, my lord.
This one you have to go back to civil court. You file for.
No, we have filed before the civil court, my lord.
orders, yes, before the matter is heard, injunction. Why don't you?
But they are trying to, but there's only small plot of land has been.
We can't now mix up this. You're asking for action with the police that we can look into. But the other things like we can't dispossession and we cannot since a.
No, because the tenant is there, my lord. It's not the entire property.
Whose side is in your side?
This is
in your side or his?
No, it's in my side, my
the
lord.
son's side.
The tenant is my tenant, my lord.
Very unfortunate. Why should the son do this to the mother?
Lordship, he is actually trying to take other properties, my lord. They are in dispute with other properties. So the mother, what happened? Since the son is trying to occupy the other properties, she files a representation before the transport department saying that I want to rescind my license. So that was pending, my lord, before the transport department. Meanwhile, the son came to know about the action of the mother.
That means your son's running the pollution testing.
Yes, she is, my lord. There is no dispute.
Derived from there goes to the son only. That means.
No, but the license, I am the license holder, my lord.
Whatever it is, that means if he is against your renewal, your non-renewal, that means he is gaining income from that, correct?
No, but that also, my lord, I have recently came to know, my lord, that license has been rescinded, my lord. But only a small portion of the land has been given to the pollution testing center, my lord. Whereas the other portion, my lord, there are tenants, my lord, in the other portions. My grievance is that, my lord, that no coercive action should be taken, my lord. That is only my grievance. Let them go for a title suit, my lord. If we have already filed title suit, my lord, that is pending before the assistant to deprecation.
What the court is saying, if the suit is pending, there are remedies under the CPC.
That is what, my lord.
Ask for any urgent orders. Yes, Mr. Sen.
It's I don't. Maybe this is a mistake, but in his miscase, there is no indication that he's prayed for any injunction before the trial court. This is at page 22.
Miscase.
No, in the main suit.
On the main suit.
In the main writ petition. He's enclosed a copy. At page 22 is a copy of the miscase that they filed before the trial court.
Yes.
This perhaps is a mistake. So this is the miscase number 1 of 24. And the prayer of this miscase is at page 34.
But if you have to produce a claim, that means?
Correct. I think it's a mistake.
Yes, Mr. Moomin.
And as far as the main prayer is concerned, there are private parties. The prayer is at page 34. It's identical to the prayer in the main suit. These are for declaration and permanent injunction.
This is the
So I think accidentally they've enclosed the wrong documents.
How can the main suit be miscase number 1?
And the prayer in the main suit is at page 49. So these are identical. I think accidentally copy paste.
Mr. Moomin, I think you have to seek remedy elsewhere.
But I'm just seeking that no coercive action, my lord, should be taken, my lord. No, with the help of the police, my lord, they are coming to dispossess the petitioner, my lord. The police are with them, my lord. No, if the respondent number 6 is claiming that he's entitled to the property, let him go to the civil suit, my lord, and take appropriate action, my lord. That is my only grievance.
Petitioner, who claims to be an absolute owner in possession of a plot of land situated at
Danakre, my lord. Danakre. Machakolgre.
Is in Tura only?
Yes, in Tura, my lord.
Danakre in Tura. Is before this court seeking a mandamus to restrain the mandamus for a direction to issue to the police respondents to take action against the respondent number
5 and 6, my lord.
5 and 6. Both of them are sons, your sons?
Yeah, both the sons. They're twins, my lord.
To be the sons of the petitioner stuff. It has also been submitted that in this connection, and with regard to the said property, a title suit is pending before the court of the
Assistant to Deputy Commissioner.
Assistant Deputy Commissioner at Tura. Was Garo Hills, and its number, title suit number 2024. Stop. It has been submitted by the counsel for the petitioner that the hearing on the injunction application has been fixed on 4/2024. But in the meanwhile, the respondent number 6 have started creating disturbances within the suit property. He therefore prays that, notwithstanding the pendency of the suit, that orders be passed to that no action, that what we want?
No coercive action, my
by
lord.
whom?
By the son also, my lord.
How would say the son?
By the police.
By the police, my lord.
That the police take appropriate action, yes. Next, para Ms. S. and G appearing for the, you have any submission to make? No.
So 1 to 4.
appearing for response 1 to 4.
Let's kindly see the prayer at page 12. As far as prayer number 3 is concerned, I'll leave it to Lordships. Prayer number 1 is to take action against the representation that they filed before the SP. So that they have a remedy under 156. Number 2 is a status quo. Their remedies again before the trial court. As far as number 3 is concerned, I'll leave it to Lordship. Because we don't know. These are their allegations.
Yes, don't know. As what is submission? Sorry.
Well, as far as the three prayers are concerned,
three prayers. What's your other submissions? That
we'll have to take instructions whether these allegations are at all true against the respondents.
Exactly, that's what. That
I'll already file an FIR, my lord. SP complaint is also there.
Submits that the instructions will have to be received as to whether the allegations contained in that petition are accurate and correct. A reference has been made by the council also to the prayers that have been that was the prayer in the petition, which he submits are unsustainable as far as prayer 1 and 2 is concerned. Next paragraph. After hearing the learned counsel of the parties and examining the materials which have been placed before this court, there is no dispute that there is no dispute as to the nature. There is no ambiguity with regard to the nature of the dispute, which is purely civil in nature, and for which a title suit has also been instituted by the writ petitioner. So the only grievance it appears is the actions taken by respondents number 5 and 6 in the intervening period before the hearing of the injunction on 4th April, which has compelled the writ petitioner to approach this court. Taking these circumstances into consideration, firstly, it is noted that this court at this stage, with regard to the prayer 1 and 2 petition, will not issue any corrections or orders, as this isn't in much as the writ petitioner can avail of alternate remedy on registrations of FIR, or for maintenance, or for restraining the respondents number 5 and 6 in any manner. With regard to prayer number 3, to direct respondent number 2 and 3 not to take any coercive action to precious property. It is expected that the 2 and 3 being police authorities.
It's 2 and 3 superintendent of police and additional superintendent of police.
2 and 3 are to act in accordance with law on any complaint and to ascertain the factual aspect. But however, as the title suit is pending, the writ petitioner has adequate remedy to file necessary applications for the grievances as stated. Yes. Accordingly, the petition is not retained at this stage and is disposed of.
Okay, sure.
You go, you have adequate remedy.
Yeah, but the only grievance is that they are taking course of action, my lord, with the help of the police.
You take course of actions with the help of police.
Lordship?
Number 2.
You also go to the police.
No, we have went to the police, my lord, but you're not taking any action, my lord. That is why.
File application, as I'm saying. If they don't take, you have a cause. You can file 153, whatever. You don't register an FIR.
We file an FIR, my lord.
If they don't take any steps, you know what to do, Mr. Mohan.
But they're not taking action. That is why we are before this honorable court, my lord.
Yes.
May it please your lordship, before my learned counsel for the petitioner makes any submissions, I'm praying that for Passover in this matter for the time being, your lordship, as learned DSG is still on legs.
Yeah.
The division bench.
Item number 3.
Yes.
May it be please your Lordship.
Yes.
Lordship, this petitioner before your Lordship are the senior science teacher of different ad hoc high schools of West Gara Hills, my lord. But what had happened in this case, some similarly situated persons earlier approached before this honorable court seeking the basic salary at par with the government science teachers, my lord. And accordingly, this honorable court was allowed and given a direction to the state government to consider the case of the petitioners, my lord. Agreed by the same, the state preferred an intra-court appeal, my lord, before this honorable court, and the honorable division bench, after hearing the matter, was pleased to dismiss the said appeal and upheld the judgment of the single judge, but with some modification, my lord, that the area salaries or additional amount which has to given to the teachers, my lord, that may be recovered from the managing committee, my lord. But thereafter, the director has released the amount to the petitioners, my lord, at the rupees of 3,59,600 per teacher, my lord. And they have received accordingly. But when the salary for the month of August and September, July and August has been released, and surprisingly, the additional amount which has paid to the petitioners has been deducted from their salary directly, my lord, instead of recovered from the managing committee, my lord. But I have given the
yes,
my lord.
Yes, what is your prayer here?
My prayer is that, my lord, the deduction may not be done directly from the salary of the petitioner, my lord. Since the direction of this honorable
be recovered from the managing committee.
My lord, the direction is at page 57, my lord, and the relevant portion is at page 69.
Page 69.
Page 67.
69, Your Lordship.
No, the direction that recovered from managing committee.
Yes, Your Lordship. It's at page 69 towards the bottom
page
of the
69, my lord, the relevant portion.
The division bench judgment, okay.
The last part, my lord.
As such, dismissed.
As such, this appeal is dismissed with modification of the impugned order to the effect that the state government can recover the amount if spent in paying the minimum of basic salary to science teacher over and above the grant and aid being paid to such institution from the research of managing committee and or of the institution in question. The time frame provided by the landed single judge, namely 6 months, is said to be have already expired. Thus, it is extended by another 3 months from the date of receiving of the said order, copy of this order. And I have annexed the statement, my lord, showing that the deduction has been made directly from the salary as currently page 85, my lord. Page 85. This is the salary released for the month of July and August. The one, my lord, the petition number 1. The total salary was 31,000 per month, and two months was 62,000. Amount deducted, less amount to be paid by the MC, 20,600. That is, my lord, 10,300 per month deducted.
Instead of taking
and deducting till date, my lord.
Yes.
Continuously.
Your Lordship, notice will have to go to the managing committees, Your Lordship. They've been made party.
Meanwhile, we stay recovery. And if you was a shake for a petitioner.
Yes. Yes, sir.
Heard Mr.
R. Islam, my lord.
For the petitioner. Have you a missed case for stay?
No, my lord. I have given the prayer in the main writ petition.
Your Lordship, this recovery has been allowed by the judgment and order passed in the writ appeal, Your Lordship.
So recovery has been allowed, but recovery has been done from the managing committee, not from the teachers. That's the only thing. Yes, sir. Heard Mr. R. Islam, counsel petitioner, issue notice. MS Zareen Ankari Energy is present on behalf of the respondents number 128.
Yes, Your Lordship.
128. So no further notice in respect to respondents. Petition takes steps for. There's so many respondents for issuance of notice to the remaining respondents within 3 days. Stop. This is, the different schools.
All different schools.
Yes,
for the teachers, how many petitioners are there?
15 petitioners.
From 15 different schools. Or come one
Yes.
petition?
Yes, Lordship.
Yes, my lord.
Thomno? Within 3 days, stop. It has been submitted by Mr. R. Islam that this court, by an order dated,
Well, order dated,
but the
data bill order dated
different bench of this
2000.
court dated 4/3/2015, while disposing of an appeal filed against appeal was over the state.
Yes, my lord.
Yes, Your Lordship.
Thomno? A division bench of this court filed against an order of single judge allowing for what does the single judge allow?
Well, page 45, my lord.
Yes. No, what does it allow? What does it allow?
My lord, directing the government to policy is allowed to financial aid at least to the extent of the basic pay of the science teacher of the government school, that is 14,100 per month as on tutor per teacher of the ad hoc aided schools. Page 50.
That không công tác not this court, the division bench of this court. A single judge, whereby the state government was directed to grant financial aid to the extent of the basic pay of the science teachers of the government schools. So, had directed therein that in paying the minimum basic salary to science teachers over and above the grant in aid, the same was to be from the resources of the managing committees. It has been submitted that, however, while allowing the said enhancement, the recovery is now being sought to be made. Is being sought to be made has been recovery is being made from the salaries of the teachers of the petitioner. Stop. It therefore prays that as the specific directions of this court is for recovery, is for managing committee to provide this amount, the said recovery is illegal. Illegal. Stop. MS that can appearing for the state respondents praises she will out to obtain instructions. Stop. Having heard the counsel for the petitioner and peruse the orders in question, stop. It is directed that till the next date, no further recovery should be made from the salary of the teachers of the petitioners herein, established after 3 weeks.
Obliged, Your Lordship.
Highly obliged.
Item number 4.
Dr. Mazika is next.
Yes,
Lordship, I pray that this matter may be taken up after some time. This
What
may
matter
be-
about? What's the matter about?
Yes. The issue relating to transfer, my lord. The lady, my lord, he is about in the stage of retirement only. Her husband also used to serve in the Assam Rifle. He died in a terrorist attack, my lord, in a mine blast. So she, my lord, is kind of helpless. We had sought for compassionate posting, which, my lord, they said that...
come then. Yes. After some time.
Daily list item number 1.
Resolved.
Well, actually, if I can take your lordship to the order dated 5/12, my lord, we had already given in writing, my lord, the proposal. And thereafter, my lord, the question arose about meeting. So we have been trying, going and going. Even last Wednesday also, we took an appointment with the...
Where's Mr. Sen?
Sen was here only, just now. So, my lord, many attempts have been made, and now he has kind of become disturbed with his condition. My lord, Mr. Sen was telling me that now they will be available if their attempt is made now. So,
Mr. You settle it. You take personal initiative and settle this matter.
No, I have, so the MD I think was preoccupied with something else. So I've suggested this week they could meet him anytime.
But
Just after 1 week.
One option.
No direction will give.
But the only thing is that...
if he let him not go, let
the wife go, Millet.
That's fine.
Yes, yes.
That's all right, I think.
That's
Fine.
fine.
I will request the wife to go. Yes. He's a little disturbed. Because
That's fine. We have no problem with that.
Yes, Mr. Chair, Sarvati submits that to finally resolve the matter, which is not objected to by... to finally resolve the matter, perhaps the petitioner may be represented by his wife. Yes, the same not objected to by Mr.
in view of the mental...
no, I won't say anything. Mr. Essen doesn't object to the same. It's expected that the matter be resolved within 1 week. It's a matter of...
All right.
Item number 2.
Wait, please, Your Lordship. Your Lordship, in this matter, we're asking for 3 weeks' time to file our rejoinder. Your Lordship, this is our second time asking for time.
3 weeks too long. The court doesn't give 3 weeks.
2 weeks, then, Your Lordship.
Yes, 2 weeks further time as per allowed for rejoinder.
Obliged, Your Lordship.
Item number 3.
My lord, as per the last order, we have to file our affidavit. I seek your indulgence, my lord. 1 week's time may be given.
What's the matter about?
It's RCW matter, Your Lordship, for considering my representation, Your Lordship.
Okay, Mr. Ninja, please respond aloud. Further?
1 week.
1 week's time for affidavit. Is thereafter and sometime.
Item number 4.
Lordship, I am for respondent number 1, and I have not completed, Lordship, the affidavit. Can he grant another 2 weeks, Lordship?
This is a matter, Your Lordship, where we have filed a petition on behalf of respondent number 2, challenging the maintainability of the writ petition, Your Lordship. I am saying that the private dispute between writ petitioner and respondent number 1 is nowhere connected with respondent number 2, Dora Strong, Your Lordship. I am asking for either strike me off or to dispose of the writ petition as being a civil dispute.
Let Mr. Nongkla is seeking some time to file here for Steamlet Kongwir.
Yes, Lordship.
Just 1 week's time. Mr. Shankar pays for 1 week's time on to file affidavit house for number 1. So Mr. Vijay the council has also raised strong objections as to the maintainability of the petition. So, this is according to
Item number 5.
Example, the state respondents 1 to 4, we have received instructions. I require some time to file the affidavit.
Only 5. 5? Not filing. Now, Mr. S and then GA for 1 to 4. And Dr. Mozika for respondent number 5. Pray for allowed for the 2 weeks time to file affidavit list thereafter and so on. Yes.
Item number 6.
What about 4?
As per the last order, we have already complied to you.
Your file?
Yes.
Lordship, I've received yesterday the counter affidavit. I'm praying
From
for
whom? From? Number 4?
from 3 and 4. I'm praying for 3 weeks' time to file my rejoinder.
2 weeks time, MS Mania. Yes, MS Mania, please.
Your Lordship,
Submits that he has
I'd
received
like to
of
draw
the
your kind
affidavits.
attention.
Yes?
I'd like to draw your kind attention. As what we've already mentioned, the counter affidavit, Annexure 4, Your Lordship.
So we're not
It's
arguing
for the
matter
creation
now.
of the new village, already created, Your Lordship. So if
That's
it,
fine, let's hear- let
it
her
can be
file a small
implemented
rejoinder.
because there's a necessary party, Your Lordship.
Who?
The new villages.
Let her examine
They have been
that.
created. As already, I'll draw
Let her
it.
examine that, yes.
Yes.
MS Ivaniang prays for allowed 2 weeks time to file rejoinder the affidavit filed by R3 and 4.
Will not be
Your Lordship, for respondent number 1 and 2, we are not filing
Yeah,
affidavit.
that's recorded earlier.
Item number 7.
Oh, much obliged. Much obliged.
Highly obliged.
Please, Your Lordship. Lordship, we have already received the affidavit from the respondent. Let the matter come up for hearing, Your Lordship.
For hearing?
Yes, Your Lordship.
Yes, MS1 submitted no rejoinder be necessary. She prays that the matter will be for hearing. And this is matter for hearing and so on. So, yes.
Much obliged.
Item number 8.
Lordship, in this matter, the affidavits are awaited from the respondents.
So waiting for the state, I request some more time. It's 2 weeks.
3. Hearing for whom? Who's respondent number 3?
It's one of the claimant.
You're a private party.
Private party.
Private party.
Oh. Okay.
Whereby he has filed only one-page objection. He has filed a one-page objection, and the DC has taken note of that.
Yes, this SNDA and so and so pray for the 2 weeks time file affidavit. Just thereafter and so and so.
Obliged.
Item number 9.
My lord, number 9 and 10, my lord, these are service matters pertaining to NILIT, my lord, National Institute of Electronics. But here what happened, like three other employees of NILIT, my lord, they've gone to CAT. 2 have come before this honorable court, my lord. So what I was praying, my lord, they should withdraw or
Yes.
they can approach the
Instructions, Your Lordship.
Instruction. Dr. Mbosika submits that since what's the institution called?
National Institute of Electronics.
National.
NILIT.
What number? Where's the respondent? This is point number 3. This is matters emanating from point number 3. Suppose matters emanating from number 3 are amenable to under jurisdiction of the San Absolute Tribunal, MS so prays for not to seek instructions. Yes. For since service matters emanating from respondent number 3 are under jurisdiction of the Central Absolute Tribunal, MS so prays for and allow time to seek instructions. So,
Item 11.
Please, Your Lordship. Your Lordship, may kindly allow us 3 more days' time to file our affidavit for the state.
what is this?
It's almost complete, Your Lordship. Just couldn't finalize it.
Yes, MS Tiangi prays for and allow 1 week's time to file the affidavit. Yes.
So, Lordship, there is one missed case filed
Yes.
by Mr. S. Jindal.
Yes.
Seeking to implicate himself as a party.
Where is he?
So I filed he's on the.
Lordship,
I'm online, so I'm also filing in course of the day only.
The objection.
Objections.
Yes, next one, Katu, on the main case, affidavit, Miss
And
case
interim
number
order.
24, stop, Mr. M.F. Qureshi submits that objection to the impleadment application will be final course for the day.
The interim order may be allowed to continue.
Just after 1 week, yes. Interim, in the main case, interim order will continue the next day.
Obliging.
12.
May I please, Your Lordship? Your Lordship, I humbly pray 2 weeks' time, Your Lordship, to file affidavit.
Only 2 weeks?
Yes, Your Lordship.
Enough. You already got instructions?
No, Your Lordship.
Okay, 2 weeks' time as prayed. Allowed to this further time allowed to file affidavit just thereafter and so on.
Much obliged.
13.
His grievance has been redressed, my lord. Matter can be closed.
Yes, correct.
Yes. He has been posted to 6 sector, Nagaland.
Let's see the instructions. Yes, a communication dated 18 March and 19 March have been produced by the landed DSCI informing that the petitioner's grievance has still been resolved and that he's been posted.
6 sector.
He has been posted.
Headquarters 6 sector, Assam Rifle, Dimapur.
Headquarters, minimum 6 sector AR from 8 AR. In this way, the matter nothing remains consideration and the petition stands closed. Copy to communication is taken on board and made part of the record.
Second call. Supplementary list item number 2.
Yes, Mr. Bhattacharya.
Lord, this matter is pertaining to appointment in Negrims, my lord.
Appointment by?
Appointment.
Tipu Sultan.
My lord.
Chauhan.
My lord.
Should be Prithviraj Chauhan, no? Tipu Sultan is. Anyway.
So, my lord, the brief fact of the case is that, my lord, pursuant to the advertisement dated 26/2/2019, my lord, for the post of filling the vacancies of 62 number of nursing officers, my lord, in the Negrims.
62 numbers of?
62, my lord.
62?
Yes, my lord.
Of?
62 numbers of nursing officers in Negrims, my lord. So that advertisement was issued in the year 2019, my lord, 26/2/2019. My lord, thereafter I applied. I sat for the written examination. I qualified, my lord. So thereafter, my lord, as per the select list or the notification dated 30/3/2023, my lord, my candidature was placed in order of merit in the waiting list, my lord, serial number 16.
Okay, 62, your number?
My lord, 62. I am in the waiting list, my lord.
Okay,
I am in the waiting list. My number, serial number is at 16, my lord. 16, my lord, of the waiting list. Now, thereafter, what had happened, my lord? 8 number of candidates out of the 62 posts, my lord. 8 number of candidates did not join, my lord.
Okay.
So, as a result, my lord, there were 8 vacancies.
1 to 8 from waiting list went up.
Yes, my lord. 1 to 8 from the waiting list were called, and so, my lord, out of that list also, my lord, 1 did not join. So that leaves again another vacancy, my lord.
Yes.
Subsequently, my lord, there was another 5 vacancies which was created due to resignation. Again, 5
resignation from the
main list, my lord. From the list of the 62.
8 plus 5 plus 1, yes.
So, my lord, 8, again, my lord, 5. So there also, my lord, serial number 9 did not join, my lord. So thereafter, another vacancy arose, my lord, which is at 6. So altogether, my lord, there were 14 vacancies. As on date, my lord, 11 vacancies have been filled. They have been called from the waiting list. My lord, 3 candidates are there. I am here only espousing my case, my lord. I am at serial number 16. So, my lord, I have
above you.
2 above me, my lord. But 3 vacancies are there. So, my lord, my number still 3 vacancies, yes, my lord. 2 due to non-joining of serial number 1 and 9 in the waiting list, my lord, and 1 resignation which had taken place subsequently.
Okay. So as according to you now, after all the final select list, waiting list, after the joining, resignation, non-acceptance, 3 clear vacancies.
3 vacancies, my lord.
Okay.
Now, I had followed up with the department on several occasions, my lord. The department on all occasions have been, my lord, saying that we'll look into the matter. But my lord, I have apprehension that probably they'll not do anything. And another important factor is that, my lord, the select list is dated 30/3/2023, my lord. So it's likely to expire another week's time, my lord. So therefore, my lord, I had to...
Yeah, Dr. Mazika. Appoint them. What is there?
But
there's a standing order also of the... I think other case also, we're doing some other case here only. There's a standing order for the DOPT also.
My lord,
that you know, that from the waiting list, like to avoid...
It's more or less similar case, my lord.
Like the earlier case.
Vacancy arising out of resignation, whether can be filled up from the same
And, my lord, even the NAGRIM's authorities, my lord, in their RTI also, they have stated that yes, it will be filled up from the waiting list, my lord.
You take instructions, we'll have it on Friday. It's only here.
Will require adjudication, my lord. The question of law is involved.
What question of law?
Whether
my lord, the RTA response which is given to me.
Vacancy arising out of resignation, whether can be filled up.
Yes, my lord will kindly, if I can kindly take my lord to the DOPT and the clarification sought by the department, my lord.
Let's see.
This 62 posts of OBC category, brother. Overall recruitment is for 230 posts, my lord.
So I'm only on OBC category, my lord. I'm not on any other category. So, my lord will kindly see, this is at page 45, my lord, annexure 5.
Yes.
Seeking clarification on appointment of waitlisted candidates from the reserve panel against vacancies arise due to resignation of selected candidates after joining the post, regarding, my lord. Now, this was the query, my lord. Subsequently, my lord, next page, my lord, comes to annexure 6, my lord, page 47.
Yes.
My lord, here if I take, my lord, to para 2, my lord, here it says you are advised to, this is from the ministry, my lord, Ministry of Health. You are advised to follow the instructions of DOPT OM dated 13/6/2000 for filling up the vacancies from waitlisted candidate, and further the same stand we followed uniformly, my lord, in all posts in the institute for maintaining uniformity and transparency. My lord, I will...
Dr. Modi, take instructions by Friday. I heard Mr. Kivi Varasaji, counsel for the petitioner. Dr. N. Mozika is present.
All the response.
And accepts with so-and-so and accepts notice on behalf of
all the
respondents who know for the notice call for stuff. The grievance with petitioner is that though vacant posts, 3 clear vacancies existing against the 3 clear vacancies are existing in the post of
nursing officer,
nursing officers
in OBC category.
In OPC category.
OBC category, he being the zone consideration due to resignations and non-acceptance of selected of these selected candidates placed above him.
Yes.
Have not been considered yet for appointment. So, Dr. Mozika Nekvara, please allow to obtain instructions by Friday. This on Friday.
My lord, I had also filed a miscase, my lord.
Friday? Well, now is Wednesday.
My lord. Oblige, my lord.
Item number 4.
Lord, this is a matter relating to transfer of a Hindi teacher serving in Assam Rifles. Hindi teacher, my lord.
Hindi teacher.
Her husband, my lord. The husband also was an ex-serviceman. He died in a terrorist attack. So she is quite alone. She had sought for, my lord, there is a policy for compassionate posting.
Where is that?
So see, the policy, my lord, is at page 46. Page 46. is the policy, my lord. Clause 22. That the individual can avail compassionate ground posting once in a service career and including the last leg posting.
This is the first prayer made for compassionate posting.
My lord, first prayer. My lord, my application was rejected, my lord.
Was rejected.
Rejected, my lord.
Where is that?
It was rejected by saying that there is a delay in making the application, my lord.
Your Lordship, Annexure 10, Your Lordship.
Annexure 10 is the rejection order. Clause para 2. It says that it should be received well in advance before the posting order is made, and therefore it has been, my lord, turned down.
Yeah, Dr. Mazika, what do you do to such situations?
My lord,
She is a
my
widow.
lord, my lord, if a lordship comes actually to my application, it is at page 21. It was made on 18 September 2023 and forwarded on 22nd September 2023 by the concerned officers. So this was well before, my lord, my posting order of December had come. All I pray for, my lord, it should be reconsidered. Any delay, there was no delay as such, my lord. So therefore, that cannot be a ground, my lord, for turning it down. Let them reconsider, my lord,
Have you
and
got a movement
accordingly.
order as yet? No.
Sorry, Your Lordship.
My movement order specifically has not come, but my tenure would end today, my lord, as per the transfer order. It is 20th of March.
Yeah, Dr. Mazika, what do you have to say?
I'll have to seek instruction.
Yes,
Can be reconsidered or something.
Because
What happens is, because this is a large scale transfer, my lord, so a time frame is given that if anybody wants to work compassionate, they should submit application within a certain time frame. It appears that the application was submitted later, my lord.
Heard Mr. B. Pathak.
It was way before time, my lord. But
Yes,
then I don't know what
Commissioner issue notice. Dr. N. Mazika's I was also accept notice on behalf of the respondent of the call for stop the next paragraph. Mr. B. Pathak, the counsel petitioner, submitted that the writ petitioner, who is presently serving as a Hindi teacher in the Assam Rifles, being aggrieved, is aggrieved with the transfer been also dated 1st December 2023, by which she has been transferred from Mokokchung to Manipur
to Sangsak.
To Sangsak and Manipur. It has been further submitted that the petitioner had submitted the representation on 18 September 2023 with a prayer for considering her posting on compassionate ground, after which she would proceed on voluntary retirement with effect September 2026. The grounds for the representation is that the petitioner is a lady, is a widow who has children to care for, and that her current situation would create a dislocation in her family, as both the children are completing the studies, are currently about to complete the studies. It is also submitted that the ground for rejection of transfer, that the same was that the same
They
was
say it is a belated application.
that
It is a belated application,
that
they
the
say.
same
At
was
page
delayed. It's also submitted that is incorrect. as much as the request by way of representation was made well within time. It is therefore prayed that interim that the, since he's supposed to move when?
Today.
Since the tenure of the writ petitioner is to complete today itself, that some interim protection be given. Stop. Next by Dr. M. Mozikal, the SCI submits and prays that he may out to obtain instructions, as this is a matter of transfer for which a service person is bound to comply with. Stop. Having heard the counsel of the parties and looking at the circumstances surrounding the case, stop, especially the fact that the petitioner is a widow and has also represented against a transfer which has not been considered on its merits. It is directed that to the next date there shall be status quo for the movement of the petitioner. Based on when?
3rd or 4th of April.
This is on 3rd April for instructions or affidavit. Yes.
Children are grown up. One is doing PhD in.
They need more. No, but it's compassionate ground. Last transfer. Why?
14.
Doesn't mean that we will allow her that she can't be.
But the problem, no one wants to go to Manipur, my lord.
Why? Because of this problem.
The current situation is such, my lord, in Manipur.
But it doesn't affect the armed forces.
My lord, the armed forces are the most susceptible persons, my lord.
But all are coming. Whoever is transferred to Manipur is coming to court on some ground.
Very sad.
My lord.
Yes.
14.
May it please, Your Lordship.
Yes, Mr. Appellate General.
This is the Weighbridge matter, my lord. And if Your Lordship would recall, I have made substantial argument.
Not complete
on
as yet.
The issue. Not completed, my lord. To be completed.
Yes.
My lord, I was first point which I was trying to show from the facts, my lord, that the prayer in the petition, my lord, if I briefly recapitulate the argument which I had from the other day, my lord.
You have ample time. Don't worry.
Yes, my lord. Kindly see the prayer.
Different case. Yes. Prayer at this stage.
Yes, my lord. Prayer at page. The prayer is at page 24, my lord.
Mr. Sen also have to reply.
25, my lord.
Yes, yes. Yes.
Prayer 25, my lord.
Yes.
Declare, first prayer, declare the withdrawal and posting of the staff by the state respondent from AMSAR in Weighbridge of writ petitioner to AMJH as illegal and unconstitutional. My lord, this was the first prayer, my lord. To direct the state respondent to post the necessary staff to AMSAR in Weighbridge of the petitioner. Declare the operation of AMJH Weighbridge as illegal and unconstitutional. Direct the respondent to act in accordance with renewal agreement dated 1st June 2022 and comply with the order dated 16 January 2024 passed by the state respondent, my lord. So far as first prayer is concerned, my lord, declare the withdrawal by the state as illegal and unconstitutional, my lord.
Yes. Today is 20th,
with regard to
yes. Sorry. Yes.
Sorry.
Yes.
My lord,
Yes.
that your lordship is aware that at AMJH Weighbridge there is a departmental Weighbridge which has been set up, and the declaration being sought is that the AMJH Weighbridge which is set up by the department should be declared illegal. Secondly, the positive ground, if I can take your lordship to the pleading on this, your lordship will see pleading at page 21, paragraph 25.
Yes.
The writ petitioner state that the action of the state respondent in withdrawing its staff from answering Weighbridge of the petitioner and shifting them to another Weighbridge is a clear violation and total deviation of renewal agreement dated 1st June 2022, and this Honorable Court order dated 28 September 2023 for maintaining the status quo. Writ petitioner states that in action of withdrawing its staff has rendered the writ petitioner helpless, as he will not be in position to operate the Weighbridge without the presence of the staff, and its action is only shift the existing Weighbridge of petitioner to the MJR Weighbridge. That the writ petitioner states that compliance of the order of Supreme Court, my lord, have issued notification dated notifying 33 checkpoint and Weighbridge come checkpoint in the different designated location. It is pertinent to mention herein that MJR Weighbridge is nowhere mentioned in the said notification. Hence, the action of the respondent is only to frustrate the status quo order passed by Honorable Court and also to forcefully shut down the notified Weighbridge of using the brute and might illegal force, my lord. That paragraph 28, my lord, kindly take note of this paragraph, which is very important, my lord. Writ petitioner beg to state that entering into commercial transaction with private parties is required to act fairly and reasonably. But in the instant case, action of the respondent seeking to disrupt the operation of Weighbridge or by the writ petitioner before stipulated period is grossly unfair and justified, as such liable to be interfered. So my submission based on the contention or the averment made in paragraph 28 is, my lord, that the admitted case of the petitioner is that it is a commercial transaction.
Okay.
Second contention which is emerging, or second point or second issue which is emerging, what my friend, my friend's client is asserting, writ petitioner is asserting that the state has not acted fairly and reasonably. These are the two contentions which are there, my lord, in the entire writ petition, my lord. If your lordship will see, I will first deal with the contention whether the government has the right to establish the Weighbridge and if it has, under which provision of law and rules, my lord. For that, my lord, I can take your lordship to the rules directly, which is at page 29, my lord, rule annexer 1.
Yes.
The government, my lord, rule 3 at page 30. The government may install and maintain
Yes.
The government may install and maintain by itself as many Weighbridges for the purpose of section 144 of the Act on such places as it may think necessary or may allow any private person, body of persons, company, organizations to install and maintain such Weighbridges on payment of lease amount to be determined in each case by government after calling tender. So there are two things, my lord, which is there in part rule 3, first part, that may install and maintain by itself as many Weighbridges for the purpose of section 144. So statutory rules, my lord, these statutory rules framed under section 138 read with section 212 of Motor Vehicle Act, my lord. You will also will see at page 30 top that these rules have been framed under 138 read with subsection 1 of 212 of Motor Vehicle Act. Yes. My lord, confer power on the government to install and maintain by itself as many Weighbridges for the purpose of section 140. So this power to install and establish Amjeha Weighbridge is clearly conferred by statutory rules. So therefore, my friend or petitioner cannot come to the court and ask for relief which is contrary to the statutory rules, my lord. And statutory rules clearly and unequivocally confer power on the state government to install and maintain as many Weighbridges as it Weighbridges for the purpose of 144 of the Act. There is no averment, there is no whisper in the entire petition, my lord, saying that this Amjeha Weighbridge has not been established under section 144 of the Act. So therefore, my lord, this prayer in my lord on this ground alone is not sustainable and this prayer is liable to be dismissed on the reading of statutory rules, my lord. Kindly see the second part, my lord.
The proviso.
No, my lord. First part was conferment of power,
Yes.
or second line of Rule 3, or may allow any private person, body of persons, company or organization to install and maintain such way bridges on payment of lease amount made to be determined in case by the government after calling the tender. So, my lord, this power, my lord, your lordship has noticed on the earlier occasion, the government may invite tender, and by inviting tender, it can allow any private person to set up the way bridges after following the process of NIT, my lord, notice inviting tender. So, so government can establish the way bridge on its own, or government can invite tender and permit the private entity to establish the way bridge, my lord. These are the two provisions. Third provision, my lord, it has to be by government, my lord. Your lordship also Rule 3 clearly says that it is by government only, not by the commissioner, the transport commissioner. Now, provide you, my lord.
Yes.
Provided that no lease shall be granted. No lease shall be granted. Lessee should be correct. Be granted permission to any private person, body or person, company or organization, unless after fulfilling all requirements of rules 4, 5, and 6 of these rules, and permission from the government in transport department is obtained. So,
yes.
Two requirements in proviso have been laid down. One, my lord, that criteria laid down in 4, 5, 6 are required to be fulfilled. And second, my lord, permission of from the government in transport department is sine qua non, my lord.
Yes.
If there is no permission, then you have no right to continue establish the way bridge under Rule 3, my lord. That is the mandate of the statutory provision, my lord. Now, my lord, 4 is not relevant because 4 is only 21 years of age, etc., my lord. 5, your lordship may kindly see.
Yes.
In considering the grant of permission, the Commissioner of Transport should satisfy itself. My lord, now, satisfaction is by the Transport Commissioner for what should satisfy himself, that the proposed place of the installing and operation of way bridge on national highway state PWD routes should fulfill the following, namely adequate parking space and lift-by facilities so as not to cause problems for traffic congestion on the highway available. That it is maintainable in a safe and appropriate manner, that the proposed location is consistent with public safety and convenience, and the provisions for off-roading the excess load is available. So, Transport Commissioner, my lord, will satisfy these requirements. His role is also stipulated in the statutory provisions that you have to undertake this exercise, which is thereof. Then, my lord, the another Rule 6 is, my lord, Rule 6, Commissioner of Transport to forward the application to Secretary Transport Department. So what will he do, my lord, after satisfying himself with all these requirements? In terms of Rule 3, the tender is invited, my lord. Rule 4 and 5, my lord, 4 is eligibility criteria. 5 is the Transport Commissioner will satisfy on the physical character and nature of the way bridge, my lord. And after he is satisfied, my lord, after he is satisfied with the requirements in Rule 5, what is required and mandated in statutory rules is complete and meets the requirement as laid down in 4 and 5. Commissioner of Transport shall forward the application with all required information to Secretary of Transport for issue of permission. So he is not the authority who has been conferred with the power to grant permission. What he has been given power, my lord, is to forward the application to the Commissioner, to the Secretary of Transport Department for issue of permission. So it is the Secretary, the Government of Meghalaya Transport Department, which has been conferred with the power under statutory rules to grant permission, my lord. Now, my lord, Rule 7, any permission referred to in Rule 6 above shall be renewable every 3 years, and no such permission shall be granted of renewed unless the proposal for grant of renewal of permission, as the case may be, is accompanied by a certificate issued by Inspector of Weight and Measures and Government of Meghalaya as to the accuracy and correctness of the device. So 7 is a further requirement, my lord.
Yes.
So the authority which has been stipulated and provided under the statutory rules and a bare perusal of Rule 3.
The whole thing is defined here. Rule 3, what it says, number of Weighbridge the government can set up as much as they feel is necessary.
Yes.
Then they then allow only by tender for any private respondent or private party.
Yes.
Then provisos are criteria for permission. Then rule number 5 defines the role of the Commissioner of Transport. Then 6 says he has to forward it to the Secretary Transport. Then there is no power of Commissioner of Transport to grant permission. And rule 7 renewal. Okay, so those are the rules.
Yes,
that are, okay.
This is the whole complete statutory scheme of the 2009 rules, my lord. Now kindly see, I have taken your lordship through the judgment, because these rules, these very rules have been interpreted by, in the case of Contempt matter, my lord, and the Honorable Guwahati High Court, my lord, the then erstwhile Guwahati High Court, my lord, dealt with this aspect. If your lordship will come to page 119, because rules I have placed, and I wish to place the authority on these rules so that my submission on the rules will be complete, my lord. I have submitted a compilation, my lord. Compilation is there on last occasion, and if your lordship will come to page 119 of the compilation, this judgment I will cite it later stage. This judgment is not.
Insurance Act.
No, my lord, your lordship has. This is page 119. Your lordship has the page 119.
Yes, 119 is this one. This which compilation?
There are two compilations, my lord, previous and a new one. And if your lordship will see the new.
One second. Yes, there's another compilation.
115.
The other compilation is only of 91 pages, 92 pages.
Oh, yes, my lord.
This other one is.
Yes, my lord. One or two, there duplicate, there are repetitions of the judgment, my lord. But be as it, my lord, if your lordship has got this Contempt Suyam judgment, my lord, page. That judgment starts in the new compilation at page, if your lordship will come to index at page 182.
159.
159, sorry, 159, my lord.
You said 119, that's right.
Sorry, 159. 159.
You just mark it. This is your first compilation or second? This is second or first compilation?
This is the only compilation in this judgment, in this read paper book.
Number 8.
Okay. Yes.
Okay. 1 second. This of 24. Okay.
Yes. And kindly see, my lord, this 159, paragraph 2, my lord. Paragraph 2.
Yes.
At page.
At page?
At page 166, my lord.
166.
Yes, my lord.
Yes.
The respondent have resisted the writ petition, my lord.
Yes. Yes, read.
Paragraph 2, my lord. The respondent have resisted the writ petition with the help of an affidavit in opposition filed by Secretary to the Government of Meghalaya, Transport Department. Respondent have contended inter alia that petitioner's permission expired on 19/12/2010 and the renewal of permission is neither automatic nor as a matter of right. Government's policy decision not to grant extension or renewal of permission after expiry of the existing term has been taken in the larger interest of public, and the same does not call for interference by the court in exercise of court's extraordinary jurisdiction under 226, my lord. So this was the objection taken, my lord. And then your lordship will come to page 3H, my lord.
Page?
3H. 3H at the same page, at paragraph 3H, my lord.
Yes, yes. Yes.
With regard to petitioner paragraph 3, with regard to petitioner's claim that some of the way bridges were allowed to function even expiry of their respective terms of the lease, the respondent have contended that those way bridges are continuing on the strength of various orders passed. Correctly state that their affidavit that the government has not granted renewal in any lease agreement as much the state government decided to set up joint integrated check on national highways so and so in order to facilitate the operation of government toll in one place and for locating such gate and various places. It is also contended by the respondent that provisions contained in 2009 rules form enabling provision and same do not disempower the government from refusing to grant extension of permission in public interest, my lord. So this was the contention which was raised, my lord, before the court. And in paragraph 5, my lord.
Yes.
Paragraph 5 in the facts of the case, my lord, and your lordship may omit. And then paragraph 13 at page. Lordship, kindly come to paragraph 13. One, 169.
Para 13.
Yes, my lord. Para 13 at page 169.
Yes.
169, paragraph 13, my lord.
Yes.
Having heard the learned counsel for the parties, learned counsel appearing for the parties, and on careful reading of the pleading as well as the material on record, we find that there is no dispute that petitioner's waybridge is situated at National Highway 44, nor is there any dispute that despite the fact that there is a provision for renewal of permission as regards the waybridge under 2009 rules, and there is an agreement between petitioner on the one hand and the government of Meghalaya on the other for renewal of lease, government has refused to renew the permission under 2009 rules and consequently lease on the ground of policy decision dated so and so. So this was the, now paragraph 14, my lord. The question, paragraph 14, the question which, question therefore is whether the refusal to renew the lease is sustainable in law. This question necessarily requires us to examine not only the nature of agreement which the parties had, but also the scope of renewal permission under 2009 rules, the validity and justification of policy decision dated 2/6/2010, and the impact thereof on the petitioner's right, if any, to seek renewal of her permission and also to the lease. While considering, paragraph 15, my lord, while considering the present petition, it needs to be noted. It needs to be noted.
Yes.
While considering the present writ petitions, paragraph 15 at page 169, bottom, my lord, it needs to be noted at the very outset that the executive instruction embodied in the notification dated 11/9/2003 prohibited installation or operation of a weighbridge for commercial purpose without the permission having been granted in this regard by Transport Department. Clearly, therefore, no person should have legally installed or operated a weighbridge in the state of Meghalaya without permission having been granted by Transport Department in accordance with procedure laid down in the notification. In fact, notification dated 11/9/2003 made it clear that pending finalization and approval of the rules for installation, regulation, and operation of weighbridges in exercise of government's power conferred under 138 2B of Motor Vehicle Act, the procedure embodied in notification dated shall be followed in the matter of installation and operation of the weighbridge. While considering the present writ petition, it also needs to be noted that agreement in question was executed on 20/12/2007 between the Commissioner of Transport on one hand and the present writ petitioner on the other. And this agreement was entered into by parties at the time when the executive instruction as contained in notification of 11/9/2003 aforementioned was in force. Coupled with the above fact, one must bear in mind that agreement in question referred to both lease and license, while the lease was for a period of 3 years with the provision of revalidation annually, subject to performance and clearance of all government dues and fulfillment of terms and conditions of the lease by the leasee. The license was granted period of 3 years, which was renewal at the time of making an application with renewal fee of 250, subject to condition that application for renewal of license was required to be made 1 month before the expiry of the term of license, with a penalty clause that failure to apply for renewal of license within time would attract termination of contract. From the executive instruction, my lord, paragraph 18, my lord, because those are 18 onwards, 2009 rules are dealt, my lord. From 18, from the executive instruction contained in the notification dated 11/9/2003, it is clear, as already indicated above, that it was illegal to install or operate a weighbridge for commercial purpose unless permitted by Transport Department in terms of conditions embodied in the said executive instruction. Even the 2009 rules do not permit installation and operation of weighbridges without permission having been granted in terms of provision contained in 2009 rules. Unless, therefore, the requisite permission is granted under 2009 rules, no installation or operation of weighbridge in the state of Meghalaya is legal. Paragraph 19. No wonder, therefore, Rule 3 of 2019 rules provides that the government may install and maintain by itself as many weighbridges for the purpose of Section 144 of Motor Vehicle Act 1988 and or on such places as it may think necessary or may allow any private person, body or persons, company or organization to install and maintain weighbridges and payment of lease amount to be determined in each case by the government after calling the tender. This shows that as far as the government is concerned, it may install and maintain its own weighbridge on such places as it thinks fit, or it may allow any private person, body or person, company or organization to install and maintain such weighbridges on payment of lease amount to be determined in each case by the government after calling for tender, meaning thereby government has the primary right to install and operate weighbridge on such places as it thinks fit, and if it is so decide, it may allow any private person's, body or person, company or organization to install and maintain such weighbridges on payment of lease amount to be determined by government. Rule 4 prohibits installing by Milord. So this line, government has the primary right, Milord, to install and operate the weighbridges on such places, Milord. I am laying emphasis on this finding of the Honorable High Court, Milord, Division Bench of the Honorable Guwahati High Court, Milord. Then, Milord, the notifications, etc., Milord, rules, your Lordship will take note that rules have been quoted by Honorable High Court of Guwahati in paragraph 21, Milord, and then 22, Milord, and 23, Milord, and then Rule 24, Milord.
Yes, Rule 6, Rule
24, Milord. Rule 6 makes it clear that when Commissioner of Transport is satisfied that application for installation and operation of vehicles is complete and meets the requirement of Rule 4 and 5, he shall forward the application with all requisite information to the Secretary of Transport Department for issue of permission. And Rule 7 makes it clear that once a permission, it is renewable every 3 years, the only condition being that permission cannot be granted or renewed unless proposal for grant of renewal is accompanied by a certificate by Inspector of Weight and Measures, Government of Meghalaya, to accuracy and correctness of device, meaning thereby licensee leasee applies under 2009 rules for renewal permission and his application is accompanied by a certificate issued by Inspector of Weights and Measures, Government of Meghalaya, as to the accuracy and correctness of device. Permission shall ordinarily be renewed. 25. What emerges from the above discussion that no weighbridge can be installed and or operated for commercial purpose without the permission from the government below. Prior to enforcement of 2009 rule, it was under the executive instruction notified on so and so that permission was being granted after 2009 rules have come into force. The permission is required to be granted under these rules. Both executive instruction as well rules speak of granting of lease by the government allowing a person to install and operate. So, Milord, I am relying on these paragraphs to submit before your Lordship is that it is the government and government alone has the power under the earlier instruction, now under the rules to grant permission, Milord. And one more fact, Milord, this order was challenged before the Honorable Supreme Court, Milord. This judgment of the Guwahati High Court was challenged, Milord, before the Honorable Supreme Court. And the Honorable Supreme Court, Milord, that order is also on record, Milord. If your Lordship will see that order passed by the Apex Court at page 37 of the paper book, Milord.
Which paper book?
Yes, the writ petition, Milord.
Compilation?
No, writ petition, Milord. Writ petition.
Page?
37, Milord.
Yes.
Milord, I also wish to flag one thing, Milord, that I appeared against the judgment in Supreme Court in this matter, Milord.
Yes.
I lost, Milord.
Yes.
Heard learned court parties, we do not find any reason to interfere with the impugned judgment.
Yes.
And then, Milord, there are certain directions which have been issued.
But this is by a different party. All India, all Northeast commercial trucks And
if your lordship will see the order name, we sought leave, my lord. We sought leave and leave was granted, my lord. And then
okay.
if your lordship will see the date of the judgment and the writ petition, my
No,
lord.
just curiosity. Yes.
Yes, my lord. Yes. So therefore, my lord, the order of the division bench of the erstwhile Guwahati High Court on the issue that it is the government and government alone is competent authority to grant permission has attained finality up to Honorable Supreme Court.
Yes.
Second contention, my lord, is
1 second.
yes.
So that the power of the government is unquestioned.
Yes, is beyond the pale of any doubt, my lord.
Okay.
That is my first second. Second submission is, my lord, on the basis of reading of rules, my lord. The division bench of the Honorable High Court of Guwahati has come to the conclusion that it can be there has to be a tender, my lord.
Yes.
Tender tender, as your lordship is aware, that first tender was issued by which the petitioner was selected in 2017, my lord.
Yes.
And the term expired in 2020. Even assuming for the sake of argument without admitting, my lord, if the petitioner would have been entitled to renewal, his term could not have gone beyond December 2023, my lord.
Yes.
Because under the statutory rules, my lord.
3 years.
3 years, my lord, 3 years, 17, and after 3 years, and
Just
thereafter, my
give me
lord,
3 minutes.
the
Just give me 3 minutes.
Yes,
I'll come
ma'am.
back. Yes.
Yes, ma'am. Yes, ma'am.
5 minutes, okay. We'll complete this everything before lunch, correct? Mr.
I'll take about only my lord. I won't take much time. I've jotted down
No, it's
the
okay.
answer.
If you take your time, we're not going to shut you down. Just come back. Yes. Yes, sorry, yes.
Yes, my lord. So, my lord, I was on the issue that
The agreement.
yes, my lord,
should go
and then I wanted
to 2023 only. That's
2023 only, even assuming that the agreement, because beyond 2023, it has to be by way of tender only, my lord, and that is the mandate of and requirement of rule, my lord. Now, kindly see, my lord, now factual parametrics of the then agreement, your lordship will see at page 40 of the writ petition.
Yes.
The agreement starts from page 39.
Yes.
And my lord, if my lordship will see the recital, this agreement is made and executed the 7th day of December 2017. The governor of Meghalaya, represented by Commissioner Transport, as an expression shall include his successor in office and assign of the first part. Now, the licensee, which expression shall include so and so, my lord. Then government is judged for setting up the Weighbridge Amsarin and Jawai so and so, where government in public notice dated 14/4/2016 invited application from interested party for setting up the Weighbridge and Amsarin for the purpose of Weighbridge and good transport vehicle on behalf of the government, whereas licensee had besides others submitted his application for the said purpose, and his application having fulfilled all the stipulated criteria was duly accepted by government within inverted comma, and the license was given permission to set up at Joy. So, my lord, in the first agreement, the clearly shows that there is a permission by the government when the Commissioner of Transport is entering into the agreement on behalf of the government.
Yes. So he's stressing on the word government.
The government, because if I'm emphasizing, my lord, that the agreement clearly shows that compliance of 2009 rules, which required permission of the government, my lord, and it is incorporated in the agreement also, my lord. This was incorporated, and kindly see this side by side, the agreement which has been entered by the Commissioner of Transport at page 64, Annexure 12, my lord.
Yes.
Now, if your lordship will see the first next page 65, my lord, where the government had given by giving a public notice on so and so invited application, my lord, same line, my lord, whereas the licensee had beside others submitted his application for said purpose, and the application had been fulfilled all stipulated criteria, was duly selected and accepted by government. Licensee has given permission to construct and set up Weighbridge so and so. Now, my lord, on next page 66, second column, second paragraph, my lord.
Yes.
And whereas the licensee is permitted to operate the Weighbridge on terms and conditions contained in this agreement for 3 years from the date of the agreement. So, my lord, there is a clear departure from the language of the previous agreement where the government has granted permission, my lord. Here, the Transport Commissioner is saying licensee is permitted to operate the Weighbridge on the terms and conditions contained in this agreement for a period of 3 years from the date of the agreement.
Yes.
The agreement, in clear terms, my lord, so no permission from the government, my lord.
Okay,
Even assuming for
the second agreement is dated when?
This is second agreement dated, your lordship will find the date on 1st June 2022 at page 64, my lord.
Permission of government absent.
Yes, permission of the government is absent, my lord.
But this is extension, they say.
So because for renewal also there is because rule 6 and rule 7, my lord, rule 3 says without permission of the government, no person can run the private, no person can run the Weighbridge, my lord. So government's permission is required at every stage. Renewal also, Commissioner of Transport is not competent to grant permission. Only government can do it, my lord. That is the statutory rules.
Okay.
And I am also supported by, my lord, the letters and documents which the Commissioner of Transport has forwarded to the government, and there is no permission granted by government, my lord. I have shown those letters. I am not taking, those letters are attached to my counter affidavit, my lord.
Okay.
And my lord, on last date of hearing, my lord, I have placed 3 judgments, my lord. In fact, 4 judgments, my lord. 5 judgments, my lord, in my compilation, my lord, on the issue that act of unauthorized officer.
Which judgments are those?
Those judgments are, my lord, first is Joshi Technology, my lord.
Okay.
First is Joshi Technology, my lord.
Yes.
The paragraph I can, my lord, 53 onwards, my lord, in Joshi Technology, and paragraph 70.1.
Okay.
These are the 2 paragraphs of Joshi Technology, 2015, 7 SCC. My lord, kindly see the index also, index of my compilation, my lord.
Yes.
The paragraphs, relevant paragraphs in the index are mentioned, my lord. Then second judgment is I have placed, my lord, Union of India versus NK Private Limited, my lord.
Yes.
And third judgment, my lord, is local. That is paragraph 8 to 10, my lord.
At 12 to 16.
At 12 to 16 of Glock Asia Pacific, my lord.
Yes.
This is a recent judgment, my lord.
Yes.
And fourth is this is a constitution bench judgment, my lord. Bhikaraj Jaipuria versus Union of India.
Let's see that, 66.
Yes, my lord, 66. My lord, first, my lord, can I place this to 2023 judgment, my lord?
Yes, yes.
2023. That is 2023. Yes, Glock, my lord. Because Glock deals with this aspect, my lord.
Yes.
Glock is at page, my lord.
52.
52.
Yeah.
Relevant at relevant at part 59, my lord. Submission regarding contract expressed in the name of President of India, my lord. The title of the paragraph at page 59.
Yes.
We will first deal with the submission of learned ASG, Ms. Bhatti, that contract in the present case stands on a different footing as it is entered into in the name of President of India. Article 299 of the Constitution of India provides that all contract made in exercise of the executive power of the Union shall be expressed to be made in the name of President. The phrase expressed to be made and the word executed are intended to mean that there must be a deed or contract in writing and executed by person duly authorized by President or the Governor in that behalf. The rationale of Article 299(1), as explained in Chaturbhuj, Vittal Das, Jasani versus Moreswar Parasuram, is that there must be a definite procedure according to which contract must be made by agents of the government in order to bind the government. Otherwise, public funds may deplete by unauthorized or illegitimate contract. It implies that contract not couched in the particular form stipulated cannot be enforced at the instance of any contracting agency. My lord, my emphasis in this paragraph is at paragraph line this, that the purpose is that unauthorized, the Honorable Supreme Court, my lord, in this, that purpose is there must be a definite procedure according to which contract must be made by the agents of the government in order to bind the government. Otherwise, public funds may deplete by unauthorized and illegitimate contract. It implies that contract not couched in the particular form stipulated cannot be enforced at the instance of the contracting party, my lord. It must be emphasized.
Yes.
It must be emphasized, my lord, that Article 299 only lays down the formality that is necessary to bind the government with contractual liability. It is important to note that does not lay down substantial law. My lord, for substantial law, 299 is there. When it comes to interpretation, my lord. Yes, my lord. That part I am not concerned with, my lord. I am only concerned with paragraph 12 and 13, where the law has been spoken in unequivocal and clear terms, my lord. Then, my lord, kindly come to Bikaji Jaipuria at page 66, my lord, and paragraph 17 with at page 74, my lord. Paragraph, my lord, Bikaji is 17 and 9.
Yes.
17, my lord.
Yes.
16 and then 17. It is clear that Parliament intended to enact the provisions contained in 175(3) that the state should not be saddled with the liability for an unauthorized contract, and with the object provided that contract must show on their face that they are made on behalf of the state, that is the head of the state, and executed on behalf and in the manner prescribed by person authorized. The provision, it appears, is enacted in the public interest and invests public servant with authority to bind the state by contractual obligations incurred for that purpose. It is in the interest of the public that question whether a binding contract has been made by the state and a private person should not be left open to dispute and litigation. And that is why legislature appears to have made a provision that contract must be in writing, must be on the face of it, so that it is executed for on behalf of the head of the state of man and in the manner prescribed. My lord. Your lordship has noticed it is in the name of government, but it is not in the manner prescribed, my lord. And for that, my lord, if your lordship will see this railway judgment where this issue was there, that the person, it was expressed in the name of the governor, but the person was not authorized, my lord. And in the railway contract, my lord, which is at page,
yes.
Page, your lordship will see 42, page 42, my lord, paragraph 8 and 10.
Of?
Of, you see, same compilation, my lord.
Jumping back there.
I'm sorry, these are the only two paragraphs I was relying on, my lord, on 17 and 18, my lord. And this is the view, my lord, reiterated in my lord, Glock Asia, my lord, in paragraph 12 and 16.
42, what paragraph to show 42?
I'm referring to paragraph 8, my lord.
Page number 48.
At page 48.
Okay, yes. Critical question.
Yes, 7, yes, 2, yes, my lord, the crucial question. And before that, also paragraph C7 also, may lordship may kindly see. That apart from the contention relating to Article 299 of the Constitution, there was no concluded contract between the parties because the essential terms were not agreed between them on the date when the acceptance letter was issued by PCO on July 15, 1968. And even if there was an acceptance as alleged, that acceptance was conditional upon formal contract being executed by appellant. That three mandatory requirements of Article 299 of the Constitution for a valid and binding made in exercise of the executive power have not been complied with. Namely, the contract was not expressed to be in the name of President, nor was executed on behalf of the President by a person authorized to execute it on this behalf, my lord. So all three issues were there, my lord. On third issue, my lord, because person authorized to execute it on that behalf, my lord. So this is the C which is there, my lord.
So what action have you taken against this officer?
My lord, he has been transferred from the department, my lord.
Transferred as punishment?
No, my lord, transfer is not punishment, my lord, but he is now verge of retirement also, my lord.
You drop proceeding against him?
Yes, my lord, but still my petitioner cannot get benefit out of the illegal act of the one of the officers.
Should we direct the proceeding be done up against him?
My lord, I leave it that, your lordship.
If you say that, if you say that the action is purely that it can, all the illegalities or irregularities can be, at the be saddled with him, so then that the government is totally removed from this entire transaction, and that the renewal is done in a sovereign fashion by the officer himself, where he should have taken steps.
Yes, my lord. Your lordship is absolutely right, my lord. Sometimes, my lord, we fail in our duties, and therefore these kind of situations emerge, my lord. Otherwise, this would not have been there.
Yes.
Because it is clearly transgression of the established statutory
Yes,
provisions.
you
my lord.
see it prescribed. That means what has been done according to your entire case is that the prescribed manner was not followed, and as such, it resulted in an illegal agreement being entered into, which is thought to be enforced by the petitioner now.
Yes, my lord. That's my precise argument, my lord. And what I was submitting, my lord, that even assuming, my lord, that the petitioner is entitled without admitting that his term could not have gone beyond December 2023, my lord. That period is already over. And that 6-year period from 17 to 2023, my lord.
Yes.
My friend can argue that there was a COVID, there was some extension, etc., my lord, but be as it may, my lord, the fact is that beyond 26, it could not have been gone.
Yes.
So therefore, my lord, on this point, my lord, all these authorities speak volume about the process, because your lordship knows that if the person who is not authorized to enter into the contract on behalf of the government is permitted to enter into the contract on behalf of the government, and those agreements are enforced on the government, my lord,
Yes.
that will be creating a kind of chaos where everybody will be independent and sovereign. And I have placed, my lord, rules of executive business on last date of hearing, my lord, where I showed that when in a democratic system, the government means that the department headed by minister, and his permission is required, which is expressed through the name of secretary, my lord. That is the rules of executive business framed under Article 166, my lord. And also, so the government here, my lord, I need not labor and go in that direction, but here government permission is admittedly not there, my lord. This is my first contribution.
Yes.
Second contention, my lord, is that the challenge in this case, my lord, is to the communication, my lord.
Consequential order.
Yes, consequential order, my lord. And for that, my lord,
82.
Yes, my lord.
Which in this edu country is Yes.
And my lord, if your lordship will see that the positive directions have been issued, that my orders which are placed before your lordship, for example, page 85, my lord. Page 85 of the paper book, my lord.
Yes.
Page 85 of the paper book, my lord. Page 85 of the paper book, your lordship will see this order also conveyed to the petitioner, my lord. You are hereby informed that agreement for operation of the Weighbridge at Answer-in is extended up to 39 to as conveyed by government in letter dated 20th June 2023.
Yes.
And this 20th, so this letter, 14 July letter is not challenged, my lord. And 28th June letter also, my lord, the petitioner has placed in the writ appeal against the interim order, and before your lordship also at page 25 in the rejoinder. Sorry, page 13 of the rejoinder, my lord. This order of the government, this is dated 20th June 2023.
First one, yes.
Annexer 2, page 13 of the rejoinder, my lord. And this is the decision of the government, my lord.
Yes.
And both the decisions have not been challenged before your lordship. What has been contended and submitted before your lordship is that the government has withdrawn, or Transport Commissioner has withdrawn the earlier 39 order, my lord, and therefore my writ petition has become infructuous so far as the first writ petition is concerned, my lord.
Yes.
For that, my lord, I need to place that order, my lord, by which 1st August order I have already shown, my lord, and the previous writ petition, my lord, 14 July letter, if your lordship will see, 14 July letter at page 85.
Yes, this is seen.
Yes, your lordship. Your lordship has seen, and then your lordship will see the 16th July letter, my lord, at page 96. That the petitioner has submitted before your lordship is that since a 14 July letter has been withdrawn, my writ has been become infructuous.
Yes.
That this letter was the only letter which was coming in the way of enforcement of second contract, my lord. That is the contention, if I have understood correctly, my lord.
Yes.
Page 85, my lord, the government decision that your permission is up to this date only is conveyed, my lord, page 85.
Yes.
That period is already over, my lord. Government decision to extend up to that date only can be withdrawn by government only, my lord. And there is no letter which has been placed by the petitioner before your lordship saying that contract has been extended beyond 30th September by the government.
Oh, just come again. Now 85 says you have an informed agreement for operation.
Yes, you are informed that agreement operation is extended as conveyed by government up to 20th June 2023.
Right. Okay.
So what was conveyed in 20th June later was, my lord, that the contract is extended up to 30th September 23 only.
Right. Okay, then.
My friend is arguing, my lord, that this withdrawal of 14 July later 2023 has rendered my first writ petition infructuous.
Yes.
Because challenge in that petition was of 14 July 2023 later only. So, my lord, this later, my lord, the term is extended up to 30 because government is not saying that the agreement is being extended, etc.
Yes.
And your lordship, 20th June later 2023
only the
is not under
only letter extending the term has been withdrawn.
Yes, my lord. That is my precise submission, my lord.
Nothing else.
Nothing else. And
can it imply anything else?
Yes. And petitioner is in
that means consequentially
of,
nothing comes alive anymore. Even that it only refers to the extension 39/2023 and the time's over, so you withdraw it. That's it.
Yes, that is
the
argument
of the court order.
Yes, my lord. And then then your lordship will also take note of two more facts, my lord. That after 14 July letter, my lord, there is a letter on 1st August also, 2023, at page 90. Of the Transport Commissioner only. 1st August 2023 letter, my lord, is written by Commissioner of Transport, and in this letter, he says, my lord, with reference to the subject cited above, I am to return here with the original copy of challan for second and third installment of annual fee of 2023, as the government has conveyed its approval for extension of the agreement up to 30th September 2023. So the Transport Commissioner has returned the challan, my lord, saying that permission is up to 30th September. Beyond that, I can't take your challan for third quarter and fourth quarter, second or third installment.
Yes.
This letter is also not under challenge before your lordship.
Yes.
Its 14 July letter is a main letter. This letter is equally ought to have been challenged, my lord. And 20th June letter, your lordship will see in the rejoinder, which is the letter by which permission is up to 30th September, my lord. That letter is also not under challenge.
Yes.
So what has been challenged before your lordship is
the withdrawal of the
yes, my lord.
The transport staff.
Yes, my lord. And those orders, 20th June order or the other orders, are all statutory orders passed, all orders passed, and those orders are standing on the face of it. And for that, my lord, Idu Kanti, I have relied, my lord, Idu Kanti.
So 20th June says,
20th June says that approval for extension of only and no more extension beyond the mentioned date, my lord.
Yes.
Where is the challenge to this letter, my lord? What is being submitted before your lordship by the writ petitioner is that this letter, I was not having possession of this letter, my lord, therefore I could not challenge it. But 14th July letter also refers to, my lord, letter of the government of 20th June, my lord.
Yes.
He could have applied for the order, he could have, because that 20th June letter is the letter under the statutory rules. Commissioner Transport is basically a post box in the entire scheme of things, where letter will come to him, he will forward those letters to the government, permission will come to him from the government, then he will sign the agreement. That's a role assigned to Commissioner Transport in the scheme of statutory provisions, my lord. No more extension beyond the mentioned date, my lord. And even assuming, my lord, without admitting that the letter was not addressed to him, this is the letter by which he is aggrieved, my lord. He is having possession of the letter and he does not challenge it, my lord. The situation would be, my lord, if his writ petition is allowed, 20th June 2023 letter will also stand, and without the same being set aside by your lordship, and then the staff will also be posted, my lord. Both things can't survive, my lord. And for this reason only, my lord, in Edu Kanti, page 82, my lord, of the judgment compilation, my lord.
Yes.
At page 94 is the relevant paragraph 22.
'94 is paragraph?
Paragraph 22, my lord.
22.
It is a settled legal proposition that the challenge to consequential order without challenging the basic order or statutory provision on the basis of which the order has been passed cannot be entertained. Therefore, it is a legal obligation on the part of party to challenge the basic order, and only if the same is found to be wrong, consequential order may be examined.
Yes.
So therefore, in humble submission, my lord, the writ should also fail on this ground when there is no challenge to main order of government of Meghalaya dated 20th June, or even, my lord, the order of the transport commissioner, by which transport commissioner refused to accept the challan in view of the order of the government of Meghalaya dated 20th June 2023, my lord. So this covers my second point, my lord.
Okay.
My third point is, my lord, that point is that, my lord, the petitioner has admitted, my lord, that it is a commercial contract. My lord, what the commercial contract in the pleading, but in argument it was being argued that it is a statutory contract.
Yes.
There was some submission on that.
No, submitted, yes. That has been submitted, the statutory contract. So, yes. Yes.
So it was pleading, my lord, that part is missing, my lord, but in the argument it has been there, but it's my duty to meet that also, my lord. My lord, statutory authority entering into contract will not make all contracts the statutory contract.
Okay.
Because there is a statutory authority, my lord, and statutory authority in this case is government. Therefore, my lord, to say that it is a statutory contract and therefore it should be bound by statutory terms, even I take that argument, my lord, is valid. In that case also, this contract has not been entered by the government, by the statutory authority. Secondly, my lord, this is my submission is, my lord, that this is not a statutory contract. This is a contract entered by an unauthorized person who is not authorized in the statute to enter the contract.
Yes.
Third submission, my lord, is, my lord, that
yes,
the nature of the, if your lordship will see the case laws on this aspect, my lord, your lordship kindly see page India Thermal Power at page 101, but relevant paragraph is at 108, my lord.
India Thermal Power.
Yes, my lord. It starts from page 101 and the relevant paragraph is at 108. Paragraph 11 at page 108, my lord.
Yes.
It was contended, paragraph 11, my lord, by Mr. Cooper, learned senior counsel appearing for the GBL and also by some counsel appearing for other appellants that appellant IPP had entered into PPA under section 43 and 43A of the Electricity Act, and as such they are statutory contracts and therefore MPEB had no power or authority to alter the terms and conditions. This contention has been upheld by the High Court. In our opinion, said contention is not correct and High Court was wrong in accepting the same. Section 43 empowers the Electricity Board to enter into an arrangement for purpose of electricity on such terms as may be agreed. 43A provides that generating company may enter into contract for the sale of electricity generated by it with the Electricity Board. As regards the determination of tariff for the sale of electricity by generating company to the board, 43(1) provides that tariff shall be determined in accordance with norms regarding operation and plant load factor as may be laid down by the authority in accordance with the rates of depreciation and returnable return and such factors as may be determined time to buy with central government and the official budget. These provisions clearly indicate that agreement can be on such terms as may be agreed by parties, except that tariff is to be determined in accordance with provisions contained in 43 and notification issued. Merely because a contract is entered into exercise of enabling power conferred by a statute, that by itself cannot render a contract a statutory contract, my lord. That is what if a contract incorporates certain terms in which are statutory, then it is said contract to the extent it is statutory. A contract may contain certain other terms and conditions which may not be statutory in character and which have been incorporated there as a result of mutual agreement between the parties. Therefore, PPA can be regarded as statutory only to the extent there contain provisions regarding determination of tariff and other statutory requirements, operating and maintaining escrow account, my lord. So the principle of law is, my lord, that commercial terms and conditions cannot be treated as statutory contract, my lord. And therefore, to say that, my lord, that this is a statutory contract, on the face of it, my lord, your lordship has seen that it is in complete violation and dehoves the statutory provisions, my lord. And taking clue from this argument, my lord, I take your lordship to the two more judgments on the issue contract cannot override the statutory provisions, my lord.
So dehoves the statute, the second agreement.
The statutory provisions, my lord.
Okay.
Now kindly see page 117, my lord. This is Anil Kumar versus Commissioner in Entertainment, paragraph 11 at page 117, my lord.
Yes.
In our opinion, paragraph 111, my lord, it is really not necessary to go into the question whether there was a valid contract between petitioner and respondent number 5 or not, because we are of the opinion that even if there was a valid contract, no contract can override the statute. Under the scheme of the act read with so and so, only licensee so and so, my lord. And then next judgment, my lord, is 119-127, my lord, AC Paul, and the relevant paragraph is again 11. At page 123, my lord.
Para 11.
Para 11 at page 123, my lord. It is true that in the policy which still have the age-old form, it is stated that amount is payable to the assured, his executors, administrators, assigns, or nominee. But certainly, if there is a statutory obligation that should prevail over the contractual obligation, no contract can override the provisions of a statute. These provisions in the statute are not made subject to any contract as such. Therefore, if the policy person amount, so then the crux of these two judgments is that, my lord, that the provisions of contract cannot override the statutory provisions, my lord, and this is well-established law, my lord. Now, there was some argument on equity also, that we have made some investment, my investment is, my lord, in dealing with that submission, my lord, the petitioner knew that his contract at best could be for 6 years, my lord. And there cannot be estoppel, my lord, against or statutory provisions, my lord. For that judgment, my lord, I rely on Nova Ad at page 128, my lord. 128, and the relevant paragraph is paragraph 44 at 152, my lord.
128.
Yeah, 150, 148, but at page, relevant page is, my lord, 152 at 152, paragraph 44.
Long judgment.
Yeah, long judgment, my lord, only one paragraph 44, my lord.
Yes.
On the equity part, my lord. Presently, we have to paragraph 44 at the foot of the page at 152, my lord. Presently, we have to dwell upon the equitable facets. Before we delve into the arena, whether appellant deserve any equity or not, we may profitable refer to certain authorities, but the equity cannot operate. In so and so, while dealing with the concept of solution on the basis of equities, Bose J, speaking for bench, stated that I am of the opinion that second solution adumbrated earlier in this judgment based on equities must be ruled out at once. These matters have been dealt with by the statute, and we are now only concerned with the statutory rights and cannot, in the face of the statutory provisions, have recourse to equitable principles, however fair they may appear to be at the first sight. 45 minutes in Rajaram Mahadev Paranjpi versus Abba Maruti Mali, a three-judge bench has opined that equity does not operate to annul a statute. This appears to us to be well established, but we may refer to White and Tudor's leading cases on equity, where it is stated, although in cases of contract between the parties, equity will often relieve against the penalties and forfeiture, where the compensation can be granted. Relief can never be given against the provisions of a statute. And PM Latha versus State of Kerala, my lord, it has been opined, equity and law are twin brothers, and law should be applied and interpreted equitably, but equity cannot override written or settled law. In Raghunath Raj Bareja versus Punjab National Bank, the court observed that it is well settled when there is a conflict between law and equity, it is the law which has to prevail. The court further ruled that equity can supplement the law, but it cannot supplant or override it. In this context, reliance has been placed on so and so. And your lordship, kindly see paragraph 55 also, my lord. And last three lines of paragraph 55 at page 156, my lord.
Yes.
Paragraph 55, a public authority like the corporation is not supported to enter into this kind of private negotiation without calling for fresh tender, especially while entering into contract for the purpose of providing bus shelter, my lord. This was in the context of bus shelter, my lord. But in our context, my lord, if the government considers under the rule to grant it to the private person, my lord, am I audible? Because
Yes.
court is not visible.
I'm following, yes.
Court's camera is off probably, my lord.
No, it's on. You're visible and audible, yes.
Yes, my lord, yes. Sorry, and now it is, my lord. So, sorry, my lord. So then, my lord, the principle which I was canvassing, my lord, is this. Now, my lord, kindly see the index, my lord, because that will be index of my paper book, my lord.
Compilation, you mean?
Compilation, my lord. Index of compilation, my lord, because I have already placed, my lord, all the judgments, my lord, if you'll Joshi Technology, Union of India, Glock, and Bhikaji Jaipuria, my lord, that is on the issue of state not bound by acts of unauthorized. Second, challenge to consequential order, I have already placed, my lord. Third, my lord, nature of statutory contract, I have also placed, my lord, judgment. Then, my lord, Nova Ad, I have already placed, my lord, act statute prevail over equity, my lord, and contract cannot over. And fifth, my lord, I have already placed the
not amenable to writ jurisdiction. With judgment.
Yes, my lord. And
contractual disputes.
You're not amenable. So, my lord, these are the 11, 12, 13. Yes, first judgment, my lord, kindly see. This is Tata Motors. At page 197, 182, it starts, my lord.
Yes.
And 48, paragraph 48 at page 197.
Page?
Page 197, paragraph 48. The court, being the guardian of fundamental right, is duty bound to interfere when there is arbitrariness, irrationality, malafide, and bias. However, the court has cautioned time and again that courts should exercise a lot of restraint while exercising their power of judicial review in contractual or commercial matters. This court is normally loath to interfere in contractual matters unless a clear-cut case of arbitrariness or malafide or bias or irrationality is made out. One must remember that today many public sector undertakings compete with the private industry. The contracts entered into between the private parties are not only subject to scrutiny under writ jurisdiction. No doubt the bodies which are stayed within the meaning of Article 12 of the Constitution are bound to act fairly and are amenable to writ jurisdiction of superior court. But this discretionary power must be exercised with great deal of restraint and caution. The court must realize that their limitations and the havoc and which needless interference in commercial matters can cause. In contracts involve technical issues, the court should be even more reluctant because most of the judges do not have the necessary expertise to adjudicate upon technical issues beyond our domain. The court should not use a magnifying glass while scanning the tenders and make every small mistake appear to be a big blunder. In fact, the court must give fair play in the joints to the government and public sector undertaking in the matters of contract. Court must also not. So, my lord, the principle which is clear.
Yes.
And 52,
so
my lord.
In this case, not because discretion has to be used because there's interplay between statutory rules and
even if you
and the action, whether it's arbitrary or whether it's unilateral, or those things that we looked at.
Yes.
And the
Yes,
contract and the agreement is an offshoot of those transactions.
Yes, my lord.
Yes.
But my lord, the crux or the ratio of these judgments are, my lord, that if there is some error or some mistake, because, my lord, while executing the contract, there could be possibility whether those errors or the mistakes or inadvertent mistake on the part of the administration will be beneficial to the government, to the public, or to the private entity. Even if your lordship will notice some error in the process, but your lordship ultimately will weigh that whether public interest will have precedence over the private interest, or so this is the last line of paragraph 52. Your lordship will see 48, last line of paragraph, that fair play in the joints to the government and public sector undertaking in the matter contract must also not interfere. Such interference will cause unnecessary loss to public exchequer. Even if your lordship will take note of the fact that there are problems, but at that stage also your lordship may weigh whether it is going to cause loss to public exchequer or not. If it is going to cause loss to public exchequer, my lord, in my respectful submission, your lordship may not interfere with the order passed by the executive, my lord. Because ultimately there are this is a two-stage test, my lord. First stage, your lordship first test will be to test whether this is proper or not, there is irrationality or not. If even assuming, my lord, that your lordship notices that there is some irregularity, at that stage your lordship will apply the second test, whether it is going to cause unnecessary loss to public exchequer or not. If it is going to cause unnecessary loss to public exchequer, your lordship may condone the act of executive which is appearing to be irrational, my lord. So this is the test which, my lord, applied in the commercial terms and conditions, my lord. And paragraph 52, my lord, of this judgment, my lord, page 199.
Yes.
That is in the context of tender, my lord, but it also applies to the facts of the case. Ordinarily, a writ court should refrain itself from imposing its decision over the decision of employer as to whether or not to accept the bid of a tender unless something very gross or palpable is pointed out. The court ordinarily should not interfere in matters relating to tender or contract. To set not the entire tender process stage when the contract is well underway would not be in public interest. Initiating a fresh tender, etc. My lord, the point which I was trying to make is this, my lord, that unless it is very gross or palpable, your lordship may not interfere even with the incorrect decision of the government. Because there has to be fair play in joints, my lord, that principle which is there in paragraph 58. But in this case, my lord, your lordship will see that 6 years have already gone. by this, and the 6 years, 2017 to 2013, have already, and even assuming if he is the petitioner, I know in my humble submission there is no case, he makes out a case, my lord, he can't go beyond 2023, my lord. Public interest will be served, either it is a fresh tender or the Weighbridge is run by the government.
Okay.
So that is the principle. If your lordship comes to the conclusion that the agreement is valid, everything is fine, but still on this stage the writ is not maintainable, my lord. And the second judgment, my lord, is State of Uttar Pradesh versus Khanji, my lord. Same principle, my lord. Paragraph, only your lordship may take note of paragraph 49 and 50. I will not place those paragraphs, my lord, but your lordship may take note of paragraph 49 and 50. Principle is the same which I had reiterated in paragraph 48 to 52 and 54, my lord. And lastly, my lord, no estoppel against law, my lord. That, my lordship, I have covered that aspect. And one judgment, my lord, separately I am placing it, my lord, because my friend has argued that PNG has not been followed, my lord. That in principle of natural justice has not been followed, my lord. For that purpose, my lord, I am placing one separate judgment, my lord, the State of Gujarat versus Meghraj Petraj, my lord. That is separate one judgment which my friend has, my colleague has, my lord, placed before your lordship. And kindly see paragraph 22.
On the point of natural justice.
On the natural justice. Paragraph 22, my lord. Though, my lord, these are all commercial terms and conditions, my lord, and and his agreement has also come to an end, my lord. He has no right to continue, because if the principle is upheld that in all terms the notices are required, my lord, we have to act as per the contract. But be as it may, my lord, paragraph 22, we are unable to see any substance in the argument that termination of arrangement without observing the principle of natural justice is void. Paragraph 22, my lord.
Yes, yes.
The termination is not a quasi-judicial act by any stretch of imagination. Hence, it is not necessary to observe the principle of natural justice. It is also not an executive or administrative act to attract the duty to act fairly. It was because in that case, my lord, facts, it was, as has been repeatedly urged by Ramaswamy, a matter governed by contract and agreement between the parties. If a matter is governed by contract, writ petition is not maintained since the public policy is not, and it's not available in private law. That is where matter is governed by non-statutory contract. Be as it may, in our opinion, on the main question, it is not necessary to pursue the reasoning further, my lord. So what the point which I was trying to make, my lord, is that principle of natural justice. So if I sum up my argument, my lord, my argument is that there is no right subsisting in favor of the petitioner.
Okay. Rights extinguished.
Right extinguished, and no right also, my lord.
Yes.
No right. The action of the government not to act on illegal agreement cannot be said to be unfair or arbitrary, my lord.
Yes.
The action of the government cannot be said to be unfair and arbitrary. Third, my lord, is that after 6 years, government is running the Weighbridge on its own. It serves the public interest, or if it goes for tender, my lord, it also serves the public interest in both the cases, and it is backed by a statutory provision in the form of Rule 3, my lord.
Yes.
Fourth, my lord, your lordship, has that consequential order has been challenged. Main order of the government has not been challenged.
Oh, that we already pleaded that. Yes.
Already. So these are my submissions, my lord. Okay. I rest my submissions, my lord.
Yes.
Please, your lordship.
You want to call, or you reply tomorrow? You
tomorrow. Yes,
reply tomorrow.
I'll not take more than half an hour.
So you can take 45 minutes also, no problem. Tomorrow we'll conclude. Okay. And please prepare your bullet points if you want to.
A bullet point also. Bullet point also. I will.
Today is very concise. Argument's good.
Yes, please. Because after 3-4 days of argument, I could summarize the argument.
Yeah, at least, thank you. I mean, at least you summarize arguments in a concise manner. Yes. Interesting case.
Great.
Yes, for further hearing, list tomorrow. Mr. Sen, tomorrow we'll complete.
Yes, yes.
We will not.
Yes, no.
Yes.
I'll not seek, my lord. I'll try, my lord, within 30 minutes.
No,
extendable by another 5-10 minutes, maybe.
You see, there are certain points it is.
Yes, yes, my lord. Very interesting.
You have noted.
Yes.
So, yeah.
I'll answer them.
Public.
Yes.
Item 19.
May it please your lordship. Lordship, I'm seeking for some accommodation in this matter, lordship, today.
This case has gone beyond steel also.
I would be very grateful if they had informed me in the morning.
I know. You pay adjournment cost to the senior counsel.
Not the cost. One aspect, my lord, I was thinking of making a submission today, my lord. Of course, Mr. Paul is not there. Anyway, my lord, since it's...
Yes, when? You take the date, Mr. Secretary.
Lordship.
The date taking the adjournment. When?
Next week.
After 1 week.
After 1 week, lordship. Highly obliged, lordship.
Afterward, you'll come after...
After the reopening.
Yes. Correct. Vacations. Yes. Yeah.
20.
Obliged.
Obliged, lordship.
Where's Mr. Sheikh? Where's Mr. Sheikh? He's left the court.
He must be here, lordship. I saw him in the other court, actually.
Who's the other side? Abraham.
He's also not here, lordship. Any other date?
None appears for the parties list after 1 week is.
21 connected.
21 connected.
25. 25.
Please, your lordship, learn the...
1 second. Where's Mr. Shulai?
Your lordship, he's on legs. Your lordship, I have received the instructions from the...
Yes, what does it say?
Departments, your lordship. We had sought instructions from the deputy
As per this
commissioner.
order.
Yes, your
Yeah.
lordship. So we had sought instructions from the deputy commissioner of East Khasi Hills, as well as from the social welfare department, your lordship.
Yes.
And as per our instructions, your lordship, there is no list of OBCs in the state.
So what to do?
My lord, that will prevail. Even the office of the deputy commissioner has said that there is no list as far as the government of Assam is valid, my lord.
Yes, so that's the thing. So should we go by the list of Government of Assam? Sorry. You want a tissue here?
And
tissue paper. Yes.
Yes, ma'am. And even that 1979 list, whether that has been cancelled or that was issued by Social Welfare Department itself, madam.
Where's Dr. Mozika?
Your lordship, in fact, he's occupied with a hearing matter, your lordship, which is going on now.
Your lordship, the list in 1979 is a provisional list only, your lordship.
Whatever it is, but that's the only list that's available. So, do you agree that the government of Meghalaya will accept the OBC certificate from Assam, as there's no OBC list? She's coach, right?
Yes, madam. Yes, madam. Coach.
Coach is not considered as other scheduled tribe here in the state.
Coach
in
is...
Meghalaya, isn't coach considered as other scheduled tribes?
Coach is, my lord, in the other part, it's Machwara in the fisherman.
Your Lordship, if I may place this
Let us see.
instruction. Your Lordship. Your Lordship, in paragraph 3 of the instruction forwarded by the DC, Your Lordship, they'd spoken about this provisional list.
Yes, it's quite categorical. Let him read it in para 3 and read the whole of para 3, the instructions. See. It was a very strange case. He's qualified, but just because there's no OBC list in Meghalaya now, he's been deprived of gainful employment. But what's the stand? But government can accept also OBC list unless they have their own list. So what of setting a precedent will allow the writ petition? MS from Thao.
Your Lordship, it may not be set as a precedent, however, maybe
let Dr. Mazika
treated
come.
as an exception case.
You just that photocopy the letter, you give a copy to the court and to Mr. Jha will take it up again. Yes. MSZ in country has which date is that letter?
15th March 2024.
Has today produced written instructions dated 15 March, so and so. She's instructed to make copies of the same. She is instructed to hand over a copy to the to supply a copy to the consulate petitioner, as well as file a copy for the court. We'll decide next year. This after 1 week. When was the recruitment done?
My lord, 2019.
Should have joined when? Training over also?
Already over, my lord. And the date of retirement is 2037.
Oh, that's all right. I mean, we're not looking at that. We're looking at the date of joining now.
My lord, my lord.
Obliged, Your Lordship.
You do that, yes. Mozika is not here.
Your Lordship, in fact, the hearing would take some time because there's a bunch of connected matters.
Before whose court?
Your Lordship, courtroom 3, Your Lordship.
Okay. Yes, on so and so as a on legs another court, yes.
28.
Majula.
Yes, Zabora. What's the matter about?
My case is that on 14/11/1985, answering to a local paper advertisement, I had appeared in a walk-in interview for job of chambermaid. And for the interview, I had brought my school certificate and one certificate of cutting and tailoring, which I submitted to the officer. And in the office, some official, under the instruction of the official, a typist there in the office, typed out my biodata. There the date of birth happened to be wrong, which I overlooked. Maybe because of the excitement at getting a job at that age for the first time and asking me to sign. I didn't go through that and blindly signed it. There the date of birth was wrong. This I didn't come to know till 2020-21. When I discovered
in 86 and you came through to 21.
Towards the end of my service, actually, I was told that I'm supposed to get ready for retirement. Then I checked up, I found that the date of birth was wrong in the service record. So I filed one application to the office that this is a wrong date of birth. My date of birth is actually 21st August 1966. But that application was not accepted. I was asked to get court order.
Yes.
So I went to the court, filed an application. Court passed an order, and there also the date of birth happened to be wrong. So I went, when the wrong date of birth came, I went again to the court for correction of that order. The court saw all the mistakes, everything, and then court corrected the date, and accordingly the order was furnished before the Shillong Municipal Board. And Shillong Municipal Board issued me the birth certificate. Which is at P. Birth certificate is at page 14, my lord. And the explanation regarding that is given by the municipal board by Annexure 2 on page 13, my lord. That the court order, earlier court order had been corrected, fresh court order was supplied, and on the basis of the fresh court order, the birth certificate had been furnished. Then I furnished this birth certificate to the office for correction of my date of birth. On 23rd 12/2022, my application was rejected.
Oh, no, sorry, come again. Then what happened after the birth certificate was given? Then?
On 23rd 12, this application of mine where I had given the court order, the birth certificate given by the Shillong Municipal Board, that application was rejected. And on the same date, I was issued the retirement notice.
On 23/12.
My lord, in reply,
1 second.
the respondent has come up with a point that the birth certificate, the school certificate was.
When did you get this birth certificate date?
Birth certificate is on page 14.
You have the date of issuance?
That is 21st August
1922.
1966.
No. Date of issue of this birth certificate is 9th of March 2022.
Yes, my lord.
That means just...
after the court order, my lord. When I went to the court.
Whatever it is. But it means that correction was done only in the same year that you're supposed to retire.
Yes.
Okay.
I came to know the mistake only in 2021.
Okay.
Then, my lord, in countering the respondent has brought a fact that the school certificate was not submitted at the time of interview. That is the plea of the respondent. That the school certificate was given actually after 11 months of service, as per the affidavit in opposition of the respondent. Now, this point is not understandable that a person is given a government job and he or she is allowed to file the educational qualification certificate 11 months later. Not reasonable to believe.
No, that we are not going to that. Where did he say that?
In the affidavit in opposition, my lord.
But one thing, Mr. Sir, in Annexure 2 of the affidavit, why is this highlighted? It looks different writing. 14 December 1964.
Lordship?
Annexure 2.
Anyway, yes. The service book. Where's the original service book?
We can produce it.
Produce it. Yes. Yes, Mr. Bora.
Yes. The counter was that the school certificate was not submitted on the
Where
date
did
of
you say that? How
interview.
does that have the bearing on the retirement? Yes.
Page 3 of the counter affidavit, 6B.
Yes.
On 16/8/99, she submitted a school certificate dated so and so, 3385. So according to the respondent, this certificate was submitted on 16/8/1999, where the interview was on.
No. See, Mr. Bora, why didn't accept it? Because at that point of time, entered service when he applied, all the testimonials should be in one. Because otherwise, then you are
No, my lord, the question
liable
not
to
to be-
change it now after 11 years
Now
service.
the question arises:
So-
will a government servant be allowed to serve for 11 months without any educational certificate? How can a job be given to a government servant
How
without
the-
educational
what's the better
certificate?
employment? That only thing. Let's see your how this is the. See this application. This is your in the affidavit annexure 1. See.
The respondent is denying that I had filed the school
annexure
certificate
1,
during
this
interview.
is application of post the chambermaid, which is signed by you. Their date of birth issue was 14 December 1964. Correct.
That is a biodata which I signed
It's
on
an
the day.
application, it's not by data. With reference, the advertisement appeared in Dongmusa dated 1/11/85. I am herewith submitting my application for the above mentioned post that I'm furnishing the following particulars for consideration and needful action. Name of candidate so-and-so, address so-and-so, not my, date of birth 14/64, qualification class 8 pass, experience pass embroidery, helping in sewing, embroidery, all kind, giant sem, okay.
Yes, Annexure 4, my lord.
Annexure 1, page 12 of the affidavit. So you have enclosed the scheduled
Oh, yeah, Annexure
certificate, certificate of training and cutting tailoring, and Indian postal order, right? So based on this, they gave you a job, and service book was made, Annexure 2, where the date of birth as your application has been shown as 14 December 64.
That is what I am talking about.
Now,
Annexure
after
1 only.
11 years, you went and gave a certificate
Yes, my lord, that
showing
Annexure 1 I am
date of
talking
birth,
about.
But you didn't ask for change of date of birth at that point of time.
No, this one, Annexure 1 is the biodata which the
It's not
one
by
which
data,
I
it's an
signed on the
application.
date of interview.
It's an application.
14th
By data
November
is different.
1985.
What's by data?
That is on the date of interview
By
I had
data
signed.
is what?
On that date, I had furnished my school certificate, my tailoring certificate,
Biodata
and
is
20
something
rupees
attached to
IPO.
an application.
And this
See,
biodata, this
is
was
something
typed by
attached
the
to
office.
See, Mr. Bora, this says application, see on top. Where does it say by data?
This application was also typed by the office. I had
See,
not
who-
come with the typed
Now, are
application.
we to go back in 1985, go back in time? Do we have a time machine, something, to go and see whether...
There was, I think,
like,
Markasa side, there was no type machine also during the
talking
time,
about
my
time
village
machine,
area.
not typing
the
machine.
typewriter was in the office. They had helped me with this. I was the only candidate, by the way. There was no other candidate.
You put your service book on next date, we will decide the matter. Yes. You have anything to say?
Lordship, I have catalogued it. I'll take a minute.
Yes.
I'll just take a minute. So I've just catalogued all the relevant documents which are part of all the affidavits. Because otherwise, Lordship will have to go through 5 sets of pleadings.
Yes.
So Lordship
This
have
is
looked at this application. This was filed on the 14th of November 1985.
Yes.
Here, the date of mentioned is 14th December 1964.
Yes.
They say that we typed it, we've denied that in our
Yes.
affidavit. The next document is at page 3.
Yes.
Is the service book which we prepared. We entered the same date, 14th December 1964.
Yes.
And this has got tampering on it.
No, this is not tampering. We've explained. We've put a sellotape on top, just to avoid smudges.
To avoid tampering, yes.
Lordship. Thereafter, page 4 is a document that they submitted in the year 1999. As per their own admission,
Yes.
this is a school leaving certificate. As per this, they've calculated their own date of birth to be a different date.
Yes.
In 2017, for the first time, she obtained a birth certificate, which is at page 5. Kindly see the date of issue, 1/11/2017. Now here the date of birth is 23 February 1967. Kindly take note of this.
Yes.
This is the first one. Consciously she approached the court. She obtained this birth certificate. Then she submitted this to us, and then subsequently again at page 6, she issued another letter dated 12th of September 2018, asking to recall this document. And she writes here, with reference to my petition mentioned above, I beg to state that the petition submitted by me in the year 2018 for correction of date of birth was in the context of the wrong information recorded in the gradation list, which recorded my date of birth as 14th December 1964. As per the rule, the only document to rely upon with regard to my age of retirement of employees of the state government, government agencies, etc., is the school certificate or birth certificate submitted at the time of submission of the application for appointment to the entry post or any post. In this connection, as the documents submitted by me in 2018 were different from the ones that I submitted in my application to the post of Chambermaid, I therefore withdraw the documents. In lieu thereof, I hereby submit a true copy of the school certificate issued by the Markasa dated 8 March 1985, which copy I have also submitted my application for the entry post in Chambermaid. As per the above mentioned school certificate, my age recorded on 31st December 84. The date that I left school was 18 years, 4 months, 10 days. From the above, my date of birth is 22nd August 1966. 22nd, not any other date, my lords. Here there's another mistake. So she says it should be 22nd of August 1966. Now kindly see, this is the first request that was made. In March 2021, 35 years after joining service. Then kindly see a letter at page 9. Lordships have it?
Yes.
Here she writes, subject correction of my date of birth in the biodata and in all official records. With reference to the above mentioned subject, I would like to request your kind authority to correct my date of birth as 21st August 1966. This is now the third date of birth that we have. In my official records, that due to the bona fide mistake, it has been recorded as 14/12/64. It has also been declared in the affidavit sworn in before the notary public on so-and-so at Shillong as attached herewith in the original. She encloses a fresh certificate where the date of birth is 21/8/1966.
Yes.
And kindly see the date of issue. The date of issue is 9/3/22. Now this, kindly also see the remarks at the bottom of the page. On miscase number 6 of 22. So the first certificate she obtained in 2017.
Yes.
She knew very well what was the date recorded there. The date recorded there was 1967. It took her so many years till 2022 to approach the court back for a correction. Now after this, she keeps writing several representations and her representations are rejected on the ground of delay. Now kindly also see page 14. We have all our ID cards with us.
Yes.
At page 14 is her epic card. Kindly see the bottom, date of birth 23/2/1967. Thereafter again, in the PAN card 67 and the last page is the Aadhaar card 1967.
Yes.
Now in addition, look at her affidavit in her writ petition, my lord, which lordships had noticed on the last date. When she filed this in February 23, she declared her age as 58 years.
Oh yes, we'll take affidavit file before court.
Lordship. So there are several different dates of birth that we have.
Yes, see, in affidavit before court, you said I'm 58 years old.
58. So there's 64, there's 67.
There is no
there's
denial
60.
that there is a school certificate, my lord.
You affidavit before the court, before the High Court.
The existence of school certificate has not been denied by the respondent.
Mr. Bora, the very affidavit you swore before this court, which is soundly affirmed on 8/12/23, finished. We'll pass orders.
My lord, the thing is that the 22nd is a typing mistake which was overlooked.
We don't go
No, the thing is that there is no denial of the fact that there is a school certificate available with the...
At page 10 of your edition. That's all. Nothing else. We're not going anywhere. Yes.
Now, this also, as I said, this was because of the faith in the advocate. That
How much faith can you have from the time you join service, having
the
faith in other
same
people?
faith she had while signing the application in the office, man.
We'll pass on.
29. 29.
Yes.
Lordship, Ma'am Shilla informed me that she is going for a funeral. She just informed me a while ago.
When then?
Let the matter come up after 2 weeks, Your Lordship.
Afternoon?
2 weeks, Your Lordship.
Or 2 weeks?
Obliged. Your Lordship.
30.
Senior Government Advocate, ask again. You do not ability of Senior Government Advocate this matter of 2 weeks, yes.
30.
Similar prayer in this matter, Your Lordship. Ms. N.G. Shilla is the conducting counsel.
Okay. 2 weeks, yes.
Obliged, Your Lordship.
Actually, I wanted to submit one ruling in support of my
You give
submissions.
citation. Give citation to
31.
the citation to the court master.
In that case.
Yes.
31.
Yes, Mr. Samarth, this.
Lordship.
Lordship, may I please, Lordship? Lordship, what I've received instruction is that, Lordship, at present there is no school managing committee. So in absence of that school managing committee, the teachers are not getting salary. So, my Lord, kindly give a direction to respondent number 4 to this.
My Lord, similar prayer I also made. Similar prayer. There is no managing committee, and the SDSEO Dadangri, despite of request to file representation to the office, I filed the representation, being the in charge headmaster now. So for calling parent guardian meeting, and salary is pending for more than 8 months now. So I just humbly pray some direction maybe to the SDSEO to contact parent guardian and be in to SDSEO Dadangri. Lordship?
SDSEO, subdivision
To do what?
To issue direction for constitution of managing committee, my Lord.
When will the managing committee expire?
My Lord, expire on 2nd February 2024, my Lord. Annex 7.
On 24, when?
On,
Sorry?
my Lord. Sorry, Annex 6, my Lord. 2nd February 2024, my Lord. The managing committee expire, my Lord. Annex 6 in my writ petition.
24. Now it's under administrative. Is under the
No,
administration.
my Lord. No, there is no managing committee.
Stop.
And which is why salary is pending for more than 8 months, my Lord.
24 March.
No, उसके पहले मेरी salary pending.
Stop. The writ petitioner. Who is a assistant teacher?
My headmaster, my Lord.
Who's the ex-headmaster, in-charge headmaster?
In-charge headmaster, my Lord.
Who's holding the post in-charge headmaster? Which school is this?
Nolbari, my Lord. Nolbari Janata GA
Nolbari.
Nolbari.
Janata. Nolbari.
Government
NLBR.
aided school.
Janata JNATA G/A UP school.
Yes, my Lord.
West Garo Hills.
But there is dispute regarding his headmastership, na?
Yes.
Then why are you praying? Unless the dispute is.
Had preferred the petition assailing the order dated 19 June 2023, whereby he was removed from the office of ex-officio member convener of Nalbari Janata G/AUP school until further orders. Stop. This order was passed by the then school management committee in its resolution dated 6/1/2023. Next, when the matter is called up for hearing today, when the matter proceeds for hearing, all the parties, including the private respondents, have apprised the court that the management committee, that the school is presently without any management committee, as the same has expired on 2/2/2024.
Yes, my Lord.
Stop. In this view, the matter, they submit that to bring a quietus to the situation, perhaps instructions may be issued to the respondent number.
Lordship.
4. Respondent number 4.
Yes, my lord.
To initiate the process for reconstitution.
Yes, my
of the new management committee.
Yes, my
and also to address the grievances of the petitioner.
With
and
regard to
also-
the salary.
And also other teachers with regard to the release of salaries, which they submit has been pending for over 8
More
months.
than 8 months,
For over 8 months term. Next paragraph, in consideration of the submissions of the counsels for the parties, and also taking into account the fact that they are considering submission of parties, taking into account the fact that the management committee of the said school has expired on 2/2/2024. It is directed that the respondent number 4, SDSEO Darengre, take steps expeditiously to convene for reconstitution of the reconstitution of the school management committee, and also to address the grievances of the petitioner as well as teachers in this regard. So, matter stands as supposed expected that the entire exercise shall be completed within 2 months.
My lord, 2 months will be more. My lord, this
Too long.
2 weeks.
But
my
your
lord.
lordship, 2 months is required, your lordship. because-
Within 1 month, till such time, the responsible 4 shall administer as well as the school. Yes.
Your lordship, kindly make it 2 months, because
Why?
Because I'll have to inform them, because I am not aware of the
Inform over telephone.
but your lordship, 2 months, because election is there in the meantime.
Oh yes.
So, yes, your election
Yes,
it's not possible, your
2 months,
lordship.
yes, for 2 months, yes. Till such time, as a constitution, the responsible 4 shall look after the affairs of the school.
My lord,
Because there is
including salaries. No?
yes, my lord.
Yes.
And my lord, my grievance is here in the writ petition. I am the headmaster, man, on senior basis. my
Doesn't
lord.
matter. He'll address that.
Yes, my
Since
lord.
the
but
old management committee removed you, unless the same one comes again and
No,
removes you again.
SDSU respondent 4 has removed. His order I have challenged, my lord. So that
he removed you.
Yes,
no,
my
it's on recommendation of the management committee at that point of time.
My lord, that
Because
is
your lordship, his qualification is under challenge here, because he is not.
Let him address. Let him address.
My lord.
You can come in. Yes.
Lordship, the petitioner, he was never allowed as a.
Now
as
you're
a
arguing the matter after you saying close the matter. Let him
yes,
do management
yes.
committee. Then you want to argue matter? We'll recall the order. You argue
What I
it.
instruct is to, I didn't get the instruction, Lordship.
Yes. You're satisfied with that?
My lord, yes, my lord, with regard to only my post, headmaster, my lord, because the respondent number
Because proper
7.
Mr. Sheikh is not here, your proper hearing
he's
is
still
required,
occupied
your
in
lordship.
Yes, my
Court
lord.
number 3, Lordship.
Only.
Then you score the order. Then you just keep that. List it after 1 week. Yes.
Yes, much
Before you.
Much obliged.